There is one information for the bar members. They have general body meeting at
For admission, item number 1.
This is which road, the Mao?
Yes, ma'am. From Kesama to Mau.
Yes, what is the status now?
Lordship, I filed my affidavit, Lordship. As far as the short maintenance contract is concerned, Lordship, that was allotted to respondent number 13 and 14. There are two stretches. One from Pesama to Kiguima, and from Kiguima to Mauget, stretch number 2. We have completed the work, Lordship.
Work complete?
Yes, Lordship.
Both?
Both.
The maintenance work.
Maintenance, the maintenance part. That was allotted to us.
So what remains, my lord, what remains is the balance work after the first contractor was terminated. The balance work. So this is just the maintenance part only. This is just the maintenance part. What remains, the first contractor was terminated after he executed about 70% of the work. Around 30% remains.
You are there.
Initially, CLM.
Initiatives.
Mr. Takamasa, yesterday's matter, while passing the order, one thing needs to be mentioned while passing that or direction for the purpose of acquisition of this 34,000 square feet area is that a direction should also be given to NSI, DCL and MOT to grant appropriate sanctions also, because that without that, they would not be able to go ahead with the acquisition. Because the money has to be paid from there. And the state of Nagaland, no money. I'll just put that, huh?
Yes.
Anybody from NHI, DCL, you are there?
Yes.
Because yesterday, you were aware of the fact that 34,000 square feet of area is required in change number 162, I suppose, 126.
What's 126?
126. So in that area, there is a question of acquisition to be done. So, but the state cannot go ahead with the acquisition unless and until there is an approval or sanction from the NHA, DCL or the MOT as regards the money. So that line I'll just insert it because I remembered in the morning. So I'll just insert that because again, there will be again logistic problem. They can't do it. Yes.
So,
Now, we have taken up this matter initially on the basis of the road being absolutely in very bad and a deplorable state of affairs.
True.
Now, how is it?
Lordship, as far as we are
You are
concerned.
the
Lordship,
amicus?
I have filed a report also, Your Lordship.
You are the amicus?
Yes, madam.
So, how is the road now?
It is motorable right now.
Huh?
It is motorable right now. It is motorable. There were certain sections in which only the WMM part had been done. So the DBM and BC level needed to be done. The NHADCL floated a contract for that part, and that part is ongoing. But apart from that, madam, the earlier contractor was terminated, and he had by then completed just about 70%. And 30% of the actual contract remains. So the NHADCL had taken some time for processing the files for retendering that remaining portion. That part is
So,
not,
there is no problem with acquisition because at one point of time, there was an issue
Right.
as regards the right of way.
Yes.
At one point of time.
it is still an issue, my lord.
It's still an
It
issue.
is still an issue. So what this OMCO decided, my lords, is that the road will be constructed on the existing RW. So now the road is being constructed on the existing RW.
And
So, but
any plans of the NHI, DCL or the MOT for the purpose of making this a 4-lane?
Not yet.
Not yet, no? Because that day I was reading some newspaper out there. So there are certain proposals to be made in respect to some, I think it is to, from in Manipur must be. Now, what is required to be done here?
Now, Lordship, with regard to the whole stretch again, for
You are
the
only maintaining a thing which is not yet been made.
Lordship,
30% is still to be done.
Yes, ma'am.
So then what are you maintaining?
the existing road, Lordship.
And the contract is over.
Yes, as far as my part is concerned, Lordship, the stretch 1 and 2, it's over. Because
So,
the status report,
Means how can it be over of a maintenance work?
Lordship, the defect liability is for 6 months. That is still upon us, Lordship. But as far as the maintenance part is concerned, we have completed as per the DPR.
So, Mr. Marcus, what is required further to do in this matter?
Your Lordship, so the short-term contractors, the existing road, the construction which the previous the contractor had done, he was required to maintain that. Now, in that portion, there were certain stretches which had been laid only up to the WMM level. WMM is just the raw stone and earth, Your Lordship. So unless it was, unless the DBM level and PC level was also done before the monsoon seasons, the entire stretch would have disappeared, washed away.
So who is supposed to do?
Pardon me, Manu?
Who is supposed to
So
do?
for that portion, they have issued again another contract.
To
And-
respondent number 30.
And that contract is now being done by the respondent number 13. But what remains, my lord, is the
So
percentage of,
any contractor has been appointed? No.
for For that person, respondent number 13 is
13,
appointed.
I have been appointed, Lordship,
Recently, my lord.
recently.
Okay.
So, Lordship, as per the.
That is ongoing.
So you will be able to, so your work is not done. You have just got another.
Maintenance
contract.
part is done, Lordship, but the new contract that has been allotted to me. Lordship, as far as the DBM is concerned, we have completed almost 3 kilometers. Work is ongoing, Lordship. And as BC, we have completed 800 meters, Lordship. Then WMM, 1 kilometer. And culvert in progress. Out of the 3, 1 already in progress, Lordship.
So it will, by what time it will be complete?
Lordship, our time frame is May.
Okay.
31st May. So it's expected to be completed within the time frame.
So as he says it to be in the month of May.
My lord.
So we postpone the matter to the month of May.
That is one, my lord. And then the remaining 26% minus whatever the contractor is doing. That the process has not yet been completed now.
That has been given any contract?
Not yet.
No.
The process is ongoing.
Ongoing.
You are appealing for whom? Oh. Judicial Council is. Okay. Okay, now what is the progress as regards this? How?
26% now.
26.
What's with respect of 26%, Lordship? The third contractor who is on the ground, Lordship, he will complete the 26%, which is flat.
So have you issued any contract?
Yes, Lordship. I have filed an affidavit, Lordship.
When did you?
And the enacting was progress, Lordship. And also the LOA is issued in the month of February, Lordship. February. And he will complete in the month of May, Lordship. That is the balance work, Lordship. 26%.
Who is appealing for that contractor?
Lordship.
Who is appealing for that contractor?
30, that is one I'm keeping.
So you are appealing for all contractors.
Lordship, 13 and 14, Lordship.
Okay. So that means all your works are to be completed by the month of May.
May, Lordship.
So this will include the WBM and all these things.
Yes, Lordship.
And what is the scope of your work as regards the WBM to be completed, done? And in respect to which chainings?
Overall, this place is 18%, he has completed 18%.
Let us not go into so much detail.
May I, sir?
Yes, please.
Sir, this stretch 3 includes the scope of work. WMM, I'm telling 2.19 kilometer total. TBM 9.38 kilometers, sir. BC 17.29 kilometers, sir. Roadside drain 5 kilometer that we have to repair. Box culvert 3 number, repair again, and major bridges repair 2 number. This is the total scope of work of the stretch 3 contractor, which is going on presently, sir. And progress is around 28% as it was brought out. So this whole work will be completed by 31st May, sir. Date has been given to the contractor, work is going on, sir.
Do you have the scope of the work with you?
Yes, sir.
Yeah,
I've
can
just
you-
read, sir.
Can you just hand over to me as regards the scope of the work
Yes,
so
we
that
will-
I make it more clear in order?
NIT will give, sir. We are having,
I can make it clear in order as regards the scope of the work. This is one part of it.
sir.
This is one part of it. This is not the 26%.
This is the only which we are talking about now, sir. Which progress is 26%. Earlier 2 stretches are already completed, sir.
Others is done.
They are repaired.
Repair work is done. 26. You know,
So only remaining is 26%,
26%.
nothing more.
26% is remaining.
26% is the progress which has been achieved, sir. Balance is
No, no.
18% they've achieved, sir.
No, we have, you see, let us make it very clear. This was the road which had 2 packages,
In fact, 3 packages, 3 stretches,
3 stretches,
sir.
of which one stretch,
Sir,
he was given the allotment work for the purpose of maintenance
sir.
of which packages?
Package 1, sir. Stretch 1,
So he was given first for package 1.
sir.
Okay. Now, as regards package 2 and package 3, what is the state? Who is maintaining it?
Sir, if I may, sir, if
Yes,
I may
please.
clarify, sir. Sir, the whole stretch is 26 kilometers basically. So we have divided it into 2
26
sections.
kilometers from
26.
here to,
From Lady to Mauget, sir.
Lere Gate to Maugi.
Till Mauget, sir.
huh?
Lere Gate to Maugi.
Lady
Lere
junction,
Lere Gate, this is not the road here, my lord.
Okay, no, so from here to the entire stretch is
26.7 kilometers, sir.
26.7 kilometers. Okay, then,
So we have
but
div-
these 26.7 kilometers is in three
in
packages.
first two packages, sir. In first is 8.4.
So there are two packages, not three.
Sir, I will.
Okay, please.
First, sir, we have given two packages, sir. We have
Okay.
divided into two packages.
So what are these?
Sir, first will be from Larrygate till Kohima, that is 8.4 kilometers, sir.
8.4 kilometers.
And
Then
second one is, sir, from Kohima till Margate, that is 18.3 kilometers, sir.
18.3 kilometers. Okay, then,
This was only for the work that has been earlier completed by the earlier contractor that has been terminated, and they were only repairing what was damaged, sir.
so these two packages were being asked to them for maintaining. Okay, but in these two packages, there is an area where 26% have not been done. It is in which package?
Yeah, that has been included in the third section. That is for the first from the starting Larry Junction till Margate, sir. The balance work that has been remaining from the.
So this 26% not done
Yes, sir.
is only in respect to 8.4 kilometers?
No, that is in the
Entire
whole
stretch.
section.
Entire
Entire
stretch.
stretch, sir.
So this package 1 and 2 were initially allotted to one contractor.
Yes.
No, it was two
It was
different
just one package.
contractors.
But
was-
in both the contract, both
Yes.
the contractors did their work,
Yes, sir.
but did not do 26% of the total area.
Yes.
Am I right?
Just want to make clear, if I may. The entire package was just one package. The maintenance was divided into two packages.
So therefore, so it was one package.
It was just one package.
So the maintenance was given into
Yes,
Two
two.
packages, sir.
But why, but there is no work done for 26 in the
From-
one package.
Yes, from the whole package.
26% was not done for the whole package.
Yes, sir.
Now they have completed the maintenance, but the default liability period is there.
Yes.
But they have not done the maintenance for the purpose of, for that, a contract was given to them, their maintenance.
Yes, sir.
And there is another contract which is now been given to them
To
for the
one-
remaining 26% of the work.
to one contractor. The first contractor, that 8.4 kilometer maintenance work. Respondent number 13 has been allotted for the whole stretch for the balance blacktopping things.
For this work.
Yes, sir.
Now, what is the scope of this work, this 26%?
Sir, as per that, sir, different items has been completed.
Understood. You must be issuing them a contract.
Yes, sir.
So in the top of the contract, it will be clearly mentioned what is the scope.
Yes, sir.
So can you hand it over to me? Mr. Mozu, you must be having a work order.
Lordship, I don't have here with me.
Huh? You don't have a work order. The work order will mention the scope.
Yes. Your worship, there seems to be a little bit of misunderstanding as far as the NHLD sale is also concerned. This contract, which has been awarded to respondent number 13, is only for DBM and BC. Other components are still remain untouched. So it is not the entire 26%. In fact, this contract was issued on the basis of my report, where I said that unless the WMM level is upgraded to DBM and BC level, the entire road will be washed away. To take care of that apprehension, this contract was issued to respondent number 13. So steps regarding the 26% still remains.
So for that, no contract has been awarded.
No, actually not.
Sir, the blacktopping,
Ah.
Actually not.
we have covered with the blacktopping, the drain.
No, that
few
is for the
items.
other parts.
Yes, sir.
But
For the-
26% have
that-
not been done.
That,
That is what
from that
one of
26
your officials just said about culverts and all these things. That is
sir,
not been done.
That is, it is not quite correct to say 26% that the contract is for 26%.
Few,
That's not correct, ma'am.
so out of the balance, the first terminated contract, the balance were few scope has been included in this so that the road becomes more travelable. Yes, sir. So that has been considered in the third section. Third maintenance contractors.
Now, you see, the PIL was initiated, I think around 2 years back,
Yes, ma'am. 22. Yes, ma'am.
must be in the month of February.
Yes, ma'am.
Now, we are in 2025, 3 years. Does it take such a long time to complete these 26 kilometers? When we hear your transport minister Mott say that we are doing every day 5 kilometers, 4 kilometers in a year, but does it take 3 years for a completion of a particular 26.7 kilometers? Do you think that this court is required to monitor these intricacies out there? You are supposed to complete and finish it off. The reason why it is required, because a person concerned, because that is the lifeline to go to Manipur. Now your government, the central government is now taking up steps for making 4 lane to Imphal or some other place, and a huge amount has been sanctioned. That is has been come up from the news. Now, if that be so, then how do you go to Manipur if you don't have this road? Tell me. How is it? That does it take 3 years to complete 26.7 kilometers? And why is it happening every time that this person is being given, this person, this amount is being given? We are not concerned to those aspects. How do you do it? How do you relate it? This road is one of the fundamental rights of the person. Then, how is it possible that it takes 3 years? Understood there was a right of way, some problem with that, but this right of way and everything has to be sorted out. Yes, NHIDCL Council, what do you say? How is it possible that it is taking 3 years for these 26 kilometers? And every time one maintenance is given, by the time a maintenance finishes, the other part again starts. What remains?
There are some circumstances where we were compelled to terminate the contract.
You understood.
Lordship.
You terminate, you have a power to terminate, you do it. It's a contract.
Lordship.
The work is required to be done by NHIDCL. NHIDCL employees doesn't have the resources by themselves to do it, so they engage contractors.
Lordship.
Now you have engaged contractors, you may engage 10 contractors, 15 contractors, we are least bothered. We are concerned in this public interest litigation as to why a motorable road fit to be used from Kohima to Mao is not there for a period of 3 years. How do you take care of that?
Watch the early contract.
And by the time you finish one contract, that is what Mr. Mozu says. The moment he says that he has already completed his maintenance. By the time his defect liability period is over, this aspect will start here for maintenance, and again you will make a construction out there. By the time, and as such, it is an everlasting job to complete a 26.7 kilometers.
Lordship, the latest contractor who is on the field, which we have engaged, Lordship, his contract is still in May, 31st May. Lordship.
I'm not concerned with,
Lordship,
we are not
that
concerned,
contract-
Mr. Ma. Mr. Jamil, are not concerned to all these things. Whether, how do you complete or not, whether it is not done or not. It is required to be complete, fit and fine by 31st of March. May.
Lordship.
Everything. If you don't complete it, matter,
Lordship,
whatever it is.
Therefore, the latest
No,
contract-
he is not in a position. That is why I asked him what is the scope of the work.
It is inclusive in the structure of work.
Strangely enough,
As well
the
as
person
TML.
from NHIDCL does not know. The council who has been appointed the contractor also doesn't know what is the scope of the work. How is it possible?
Lordship,
It has taken less time for the bridges out there while coming from Gauhati to Nagaon, all the big bridges, which will, I think, come to around more than 26.7 kilometers to be completed. So you could have, as of now, if this is the time limit, you could have had a bridge from Nagaon, from Kohima to Mao, could have had a bridge, an overbridge. Forget about the roads. But the road is taking more than that. Has there been any undertaking given for completion of the entire work of this 20? We are not concerned how much, which package, which not package out there. It has to be completed. Isn't it, Mr.?
Yes, my lord. Yes, my lord.
Can it take forever, this thing?
No, it should not take forever.
We are concerned, we are not actually concerned what the contractor does. If the contractor fails to perform his duty, NHIDCL has the resources to take action, blacklist them, whatever they want, they can do it. We are not concerned. This is a public interest litigation. For what we are concerned out here is either if there is some logistics problem on account of the administration, we help you out. That is why the matter has been pending. Whether he has done it or not, we are not concerned. It is your duty to do it. To maintain the roads. Maintenance of the road is the duty of the state, isn't it? You employ them as contractors, whether they do or not, you take them, impose penalty, liquidate it, unliquidate it, whatever maybe you feel like you do it. But under no circumstances, you can just shut off your responsibility.
As far as the new contract is concerned, also it is a good progress.
I'm not concerned. Mr. Gwame, we are not concerned with all this thing. It has to be completed by 31st of March is an undertaking given by NHIDCL. We are not concerned how they do it. If they don't do it, take action against them. We are not going to send on those aspects. The PIL is only to help you out. If tomorrow the government out there is not helping you out, there's some land problem, this police protection and all these things we are going to do to them. But otherwise, we are mainly concerned as to the road using of the road from here to motorable using road from here to there, which is the lifeline. It is something similar, Mr. Takama sir. The road from there, you are now making a 4-lane from there, and this chainage of this area, which has not been done properly by the state highway authorities. The same. Now they are not making this road properly, and now they are making in Manipur 4 lanes. How a person will go and use the 4-lane unless they are in a position to use this 2-lane? Or is there any geographical signs which can permit somebody can do that? But think about something like in Kaziranga, we are thinking of having an elevated corridor, entire stretch of Kaziranga. Think about that. It should be around 26.7 kilometers. Pulling, have something like that. Isn't it? But it cannot take for all times. It is your duty, NHIDCL, to maintain the roads. How you do it, it is your lookout. You are a big organization. You have your resources, everything over there. You can do it. If this person is not doing it properly, throw him out. Have somebody else. But he has to complete it.
Since the contract is due in May, and
very well. You complete it by May. But May is May. It cannot be made. I suppose it is May 2025. Not in again 2028.
very good. Authority engineers appointed to supervise how what we do. So you'll be in a better position.
Because we are not here to enforce your powers upon him. You have a power contractually to exercise.
What may also kindly appreciate it, we have also appointed an
What is happening in this matter? What is
monitor
happening in this matter
progress.
or the matter where Mr. Takamasa is appearing in that matter?
laws.
It appears that the court is being used for the purpose of pressurizing the contractors. We are not bothered. We are concerned with NHIDCL. It's a state authority. It is to maintain it. How NHIDCL takes up the action that is looked up. There are some problems faced. by the contractor, by the NHIDCL. Actually, it is the problem is faced by the NHIDCL. Because a contractor is their agent. So NHIDCL is facing these problems. So under such circumstances, we help them. This is the purview of a public interest litigation. So that the public is in a better position to use the infrastructure. Any undertaking given by 31st May, they are completing?
That's the term of the contract.
He is okay, NHIDCL.
Can I say something?
We are concerned with you. You give your undertaking.
Between the two parties.
We are not concerned how you get it done. You take action, do whatever may be. How you give an undertaking to the effect when you are completing it. You just cannot come up and say that, okay, the contractor has given an undertaking. You have, when you issue a contract, you have a period mentioned. Isn't the time the essence of the contract? It is. Then. So you give an undertaking.
Yes, let them file an affidavit now. Let them file an affidavit now.
Yes, file an affidavit when you are completing. We are not bothered. It cannot take so long for completion. Now you are going to have the problem of acquisition is not there. Problem of ROW is not there with you because we are having on the old road itself. There's no problem with an ROW. Then why are you not completing it?
Make sure that we complete on time, lordship.
Not make sure. Make sure is not the day. Give an undertaking. We take it up with them. We take it up with the authorities because the authorities we are concerned. We are not concerned with the contractor. Whatever the contractor does done, that is their lookout. You have the power. You have the power of termination. You have the power to impose liquidated damage. Impose. You are appearing for NHIDCL. What is your name?
Sir, Rupesh Kumar, sir.
Rupesh Kumar. And your designation?
Sir, graduate engineer, sir. Graduate engineer, sir. PMU Jakama. NHIDCL from PMU Jakama.
What engineer?
Graduate engineer, sir.
Graduate engineer. Okay. Now, you are not the authority. Are you the authority? Who is the authority?
General manager.
Yes. What is your name?
I'm Anand Kumar, sir.
You are the general manager.
Deputy General Manager.
You are the authority.
Sir, I'm
Now, Mr. Anand Kumar, we are concerned with we are concerned with completion of the work.
I know, sir.
How you do it, with whom you do it, that is your lookout. It is not for you. Have some difficulty in progressing with the work on account of law and order per situation. We are going to help you out. There's no problem with that.
Yes, sure.
But the question is, how you tackle with the contractors is not the duty of the SCOT. And we are not concerned with their undertaking. We have to get an undertaking from you, how you get it done.
Sir.
So can we have an undertaking when you are going to complete it?
31st May, sir.
Put it on affidavit. I'll put it today on that you have stated. But within 7 days, put it on affidavit. I'll fix the matter after 31st May.
Sir.
But you put an on an affidavit within 7 days that the work will be completed by 31st May.
Will do,
How you get it done, that is their look.
will do, Your Honor.
No.
Yes, sir.
Heard Mr. A. Jimomi, the learned amicus curiae, appointed by the SCOT. Mr. Wait. You are NHIDCL.
I'm requesting 128.
How many persons are there? State is there. And what are you doing? You are for? Huh? Authority engineer. Okay. So authority engineer is the main person. So who is in charge of overseeing the work? This particular, he.
Yes.
So you filed the affidavit that you are going to complete by 31st.
Can I check this as well as myself, I believe.
Are you not, I mean, are you not an authority under working for the NHIDCL? Then why NHIDCL has to do it? It is you who is the person.
They are the ones who are the, if there is delay in the execution of the work.
No. No, are you not an authority appointed by NHIDCL to oversee the work? Are you not responsible for the completion of the work? So you are to give an affidavit. And what is the rank of a authority?
The name itself is operating engineer. Operating engineer.
Mr. Anand Kumar, what is the rank of the authority? You are the deputy general manager. And what is the rank of an authority?
They have got team leaders, sir. They have got engineers. Team leader is the in charge of whole works.
There is a team leader.
Team leader of the engineer is the in charge of the whole works.
So who is actually in charge for completion of the work?
NHIDCL.
Not authority.
Not this one.
Okay, sure.
The authority engineer is also an agency of the NHIDCL.
Okay, check it. Hello. Heard Mr. So-and-so, the link amicus curie, full stop. Mr. Sentianger, the learned counsel appearing on behalf of the respondent number 10. Mr. You are for Mr. Mr. Aim Song, the learned counsel, additional advocate general in the state of Nagaland, comma. Mr. Sentianger, the learned counsel appearing on behalf of the respondent number 10. Mr. N. Mujui, the learned counsel appearing on behalf of the respondent number 13 and 14. And Mr. Muajami, the learned counsel appearing on behalf of 1, 2,
1, 2, and 8.
1, 2, and 8. It was Aguadigo, Miladigo. Okay. The file has become so big that nowadays we only get the order sheet, which is of this size. Yeah. On 2/3/2022, this court, taking into account the deplorable condition of the National Highway number 2 between Dimapur and Imphal, between Kohima and Imphal.
Kohima and Mogate. Kohima to Mogate.
Kohima and Mogate. But National Highway number 2, na?
National Highway number 2. Yes.
Had taken sumo to notice of the same and initiated the instant proceedings, being PIL number sumo to instant proceedings. Fusto. The distance of the road in question is a mere 26.7 kilometers. Fusto. 3 years have gone by, more than 3 years have passed by. In spite of various directions being issued. So that, in spite of various directions being issued, the said road is yet to be completed. The agony faced by the people traveling from Kohima to Mon and further beyond still persists. The various orders passed by this court shows that necessary that this court have taken all steps so that the NHIDCL, who is the authority responsible for the maintenance of the road, is to carry out the work without much difficulty. First, Mr. Ijimomi, the learned amicus curiae, has brought to the attention of this court that out of the 26.7 kilometers, out of the entire stretch of 26.7 kilometers, road 26 kilometers, 26% of the said distance and the 26% of the said road is yet to be completed. Mr. M. Monjoy, the learned counsel appearing on behalf of the respondent number 13 and 14, submits that a contract work which was awarded to them for the purpose of maintenance, short-term maintenance, have been completed and have already been completed. And presently, the said area is under the defect liability period.
Yes, 6 months.
First, Mr. M. Monjoy further submits that for the period, for this 26% of the work which is yet to be completed, a work order has also been issued to the respondent number 13.
30.
First, Mr. Muajami, the learned counsel appearing on behalf of the NHIDCL, submitted that the same 26% of the work would be completed by 31st of May 2025.
Okay.
And in that regard, the respondent number 13 has also given an undertaking to them. To you,
Yes, in-
they have stated to you.
Yes, it's in the agreement.
First, we have also heard Mr. Anand Kumar, the Deputy General Manager, as well as Mr. Rajesh Kumar, the Graduate Engineer, who are authorities, who are Rupesh Kumar, the Graduate Engineer, who are employed with the NHIDCL. First, Mr. Anand Kumar, the Deputy General Manager, had submitted before this court that the work in question would be completed by 31st of May 2025. And the entire stretch of 26.7 kilometers would be in good condition, good motorable condition. First, we have also given our anxious consideration to the aspect that the NHIDCL is the authority who is required to maintain the road from Kohima to Mongate. And as such, it is their responsibility to ensure that the work is completed within the assured period as submitted before us. We also understand that the NHIDCL have contractual relations with the respondent number 13 and 14. And in terms with the contractual obligation, in relations, agreement, contractual relations, the NHIDCL is also in a position to take appropriate steps. Taking into account the above, this court, we direct the Mr. Anand Kumar, the Deputy General Manager, to file an affidavit before this court within 7 days from today, to the effect that the work in question of from Kohima to that gate,
Mao Gate.
No, Mao Gate is okay. Kohima to, it's Kohima or Lenin Gate?
Lenin Gate to Mao Gate.
Gate to so and so, which is a distance of 26.7 kilometers, would be completed on or before 31st of May 2025. Fusto, list this matter for an update on 4th of June 2025.
Lordship, if I may, Lordship, because as far as my part is concerned, Lordship, we're leading the work, Lordship. But the Manipur bound land trust, which land trust, they are always parked in the highway. So we have issues regarding that, Lordship. So if the
what trucks?
Goods laden truck.
Ask them to remove it. Manipur, we are here for this place is to Mao Gate is to Manipur, no. Okay.
This is the main route to Manipur.
No. From Mao Gate, Manipur will start. So this is before that.
Yes. So in between, from Lire.
So you know what is to be done. Yesterday, this is the thorn, which thorn will become later on cancerous.
If the administration can be directed so that there's.
Why should they? Why, if you have just come up with this gives you an excuse. No, nothing to it. You have all along given an undertaking before all the authorities concerned that we are going to complete by 31st of May. The authorities is coming up before this court and said that yes, we believe they are undertaking, and now when I pass this order, now you are coming up with this thing about the way. You know what is to be done. You ask the police. Have you approached the police? Have you approached the police? No, don't come up with this type of excuses.
No.
Yes.
Lordship, I think you mentioned item number 37 for hearing from the supplementary list. Second last, supplementary logic.
No, this is another one. Okay.
37, this item may not reach today, let it be listed on Tuesday logic, 8, that will be 8, on 8 Tuesday. I am for respondent of the tree logic. Consider the parties logic.
Mr. Takamasu, the senior counsel, appearing on behalf of the respondent number 3, 6 for an accommodation. To list this matter again on
8, Tuesday logic.
8th of April 2025. But not likely to be done on that date. The bench is changing. There will be different judges coming.
We also mentioned items 15 and 16. Hearing them. I'm always, we are otherwise very much, but because of the meeting today, this matter can be taken up on Monday.
Mm. 15 and 16.
Yes, madam.
Can we make this after 2 weeks?
2 weeks. At request of the councils appearing on behalf of the parties, matter stands adjourned to be listed after 2 weeks.
May I please come? Lordship, I'd like to mention item number 18. In this matter, Your Lordship, I am yet to receive instruction with regards to the additional affidavit filed by the petitioner, Your Lordship. If the matter can be listed after 2 weeks, madam.
Mr. So-and-so, the learned counsel appearing on behalf of the respondent. 6 for an accommodation. For filing an affidavit.
Additional affidavit.
For filing an additional
Yes.
affidavit. This is the matter again on 6th of May 2025. In the meantime, the additional affidavit be filed by 30th of April 2025.
I'm the lord. May this my lordship. Lordship, that detached writ petition that was detached from the contempt that my lord asked me to mention today. Writ petition 21/2024.
Can we take it up tomorrow?
Tomorrow.
Because you have some problems today.
Lord,
There's some problems with the bar. They are having some meeting. And it is likely to
Lordship.
continue beyond 2 o'clock. I have no problem. I'm here
Lordship,
till
Lordship.
4:45.
File it to my lordship.
When do you want it? When do you want it? You want to attend the bar meeting? Or you want to do the court?
Yes, lordship, that's why I'm leaving to my lordships.
Don't leave it to me. I'm asking you.
Lordship.
Tomorrow?
It's a fixed item, lordship, because
Tomorrow.
the widow is suffering.
Next, Lordship. Lordship, I beg to mention item number 17, Lordship, for the petitioner, taking the counsel of the government as well as the private respondents. Let me come up to 2 weeks, Lordship,
You are for the?
for the petitioner.
The request of the learned counsel for the petitioner matters then adjourned to be listed after 2 weeks.
Lordship, I reply.
This lordship, I beg to mention item number 21 hearing night. I beg to accept nothing be adjourned or read as continues under the things matter.
Otherwise, if the matter can be taken up tomorrow, Lordship.
Why? What is the matter about?
It's contract matter, Lordship.
Contractual?
Yes, Lordship. For construction of a multi-purpose building in
You are a
whether in
petitioner.
my village or the petitioner's village, Lordship. I'm appearing for respondent number 3, though my name is not reflected in the cost list.
But there is a stay order operating.
The direction given by the court is that the construction of the multi-purpose building shall be subject to the outcome of this petition, Lordship.
So you've constructed.
No, Lordship.
Okay,
Order is yet to be issued.
you give an undertaking that you'll indemnify if he constructs and where you lose the case. Give an undertaking. Matter over. You can go ahead and construct, and if you win, she loses, she will pay the. No?
Yeah. Emotion is better if my senior takes it.
Huh?
Emotion is better if my senior takes it.
24, Mr. Zamir is there on the backside. Then
My assistant junior is in Delhi. Okay, so we'll be back only next week.
you have got a host of juniors out here in that matter.
But I have chosen, I have particular as
Is it the practice the senior chooses or the junior chooses the senior counsel?
Required for the level here.
Okay, when?
Next week.
A request of the council for the petitioner Magnus and Jejon to be listed on 9th of April.
My lord, nine, I believe nine is.
No, there will be 3 judges here,
My lord, my
so
lord.
there will be a single bench.
My lord, my lord.
Don't worry.
Lordship,
9th
if
of
my
April.
name may kindly be reflected in the cost.
Huh?
If my name may kindly be reflected in the cost.
The name of Mr. Swenso will be reflected in the cause list as counsel for the respondent number 3.
Three, Lordship.
No, not for respondent number 2 and
Lordship,
3.
yes.
Mr. Swenso appears on behalf of respondent number 2 and 3.
Lordship.
Okay, now let us proceed. No more adjournments. Adjournment period is over.
May I please, Lordship?
No more.
My lord, I beg the permission, item number 10, my lord.
Doctor 10 doesn't arise. These are hearing matters. Other than receive one.
From the supplementary cost list for motion, item number 22.
This matter is coming up for motion for the second time, Lordship. On the last occasion, it was listed on 28th of March. And respondents were directed to produce the reports. At the same time, a query was also made by the Honorable Court. I am appearing for respondent number 2, 3, and 4, Lordship. Whether the work has been commenced or not, that was the query. The 35% of the work has already been completed, but I'll place the reports later on at the later stage, Lordship. But so far as records are concerned, Lordship.
Yes, madam. Tell me what's the case?
This is related to contract matter. The official respondent had initiated inviting the eligible contractors for construction of girls' hostel at Government Polytechnic, Sitekema, Chumkedema, Lordship. And as for the
You are the L2. You are the L2
yes, Lordship, L2,
and he's the L3.
L3, Lordship,
He's L3.
yes, Lordship,
L3 has been given without due consideration L1 and L2.
yes, Lordship.
That's your case. Comment?
I don't have, what are still respondent number 1.
Fantastic. So tell us, why have you given? Huh? So who has given this contract? You are there.
Lordship, I am Lordship. I am
Okay.
appearing for respondent
Why-
number 2,
why have you
3,
given-
and 4.
Why have you given to L3?
Lordship, I will just place the record will speak. I have given the flags.
No, it's okay. Why have you given it to
Lordship,
L3?
it's like this. On 13th of September 2024. A technical evaluation committee was set. There, they have taken a decision to in what manner the tenders are to be evaluated. So far as the present tenders are concerned, the meeting was set for two projects, two works. We are concerned with the construction of girls' hostel at Setekima Polytechnic. Now, the rates, prevalent rates in the state is 6 point something below SOR 2021. And then the project cost was projected at 9 point something percentage below SOR. The rate which is applicable in the entire state is 9 point something below SOR. Now, the project which has been prepared was the code in the project was little below than the prevailing rate. Therefore, the evaluation committee has taken a decision that any tender who quote the rates near to the estimated cost, then only the work will be, the quality workmanship will be there. And if it is
But was it informed in the advertisement that there will be a rate?
everything is there.
Let's
So
see the advertisement where we mentioned that clause. As regards the financial,
it is 8 under Lordship,
where is the tender document in the place?
page 20, Lordship.
Evaluation and comparison document. Evaluate and compare only the bids determined to be substantially responsive. In evaluating, the employer will determine each bid at the bid price by adjusting the bid price, making any correction for errors, so and so. Making appropriate adjustment for it. Now, did you take steps in terms with 29.5?
Lordship, I will just place the records and
No.
refer to the relevant.
No, it's okay. You have the record, you have read the record, you have had the time to read the record. Now, my question is, did you take any steps in terms with 29.5? Page 39 of petition.
Page 39.
Yes.
If the bid of the successful bidder is serious and balanced in relation to the engineer's estimated of the cost of the work to be performed under the contract, the employee may require the bidder to produce detailed price analysis for any or all items of the bill of quantities to demonstrate the internal consistency of those pricing with the construction methods of the schedule proposed. After evaluation of the price analysis, the employer may require the amount of the performance security set forth in clause 34 to be increased at the expense of the successful bidder to a level sufficient to protect the employer against financial loss in the event of default of the successful bidder under contract.
This is the basis on which you are going. You are saying that we have a base rate. And anybody who comes nearby to the base rate, you are going to grant it.
Yes.
Although that is not the term of the contract.
Yes.
It was done subsequently. Subsequently, you cannot change the rules of the game. What you can do otherwise is very well, you can employ 29.5. Did you employ it?
Lordship, even in the condition for award of contract, kindly come to page 40, Roman 2. This is paragraph 30 point Roman 2. To be within the available bid capacity adjusted to account for his bid price, which is evaluated the lowest in any of the packages opened earlier than the one under consideration. This will be important. If no case, in no case, the contract shall be awarded to any bidder whose available bid capacity is less than the evaluated bid price. Even if the said bid is the lowest evaluated bid, the contract will in such cases be awarded to the next lower bidder at his evaluated bid price.
Okay.
And then the employees right.
What is the evaluated bid price?
Lordship, just for our clearance, I would like to place the record. I will refer to a relevant decision of the board. Starting from flag A. That is the notification. Flag A is page 188. Flag A, page 188. This is the constitution of the Technical Evaluation Committee, and Lordship will find the members of the committee here from 1 to 6. The members are the representative from different departments.
Okay. Then,
And then come to next page, page 189. That is flag P. That is the meeting circular for Technical Evaluation Committee, which was scheduled to be held on 12th of September 2024. But due to unavoidable reasons, it was rescheduled. Flag C. That is 12th September. It was rescheduled to 13th September 2024.
now what is page 191?
191.
191.
This is not relevant, Lordship.
Now here the bid opening summary has been rejected. This is
Yes,
the petition.
that was a mistake, Lordship, by the engineering wing.
Huh?
That was a mistake committed by the engineering wing, where the name of the petitioner is also shown in serial number 2 among the rejected list. But then later on, it was found out the envelope was there. So it was a mistake.
Well-
192, this is a very important meeting where the decision was taken by the members how to evaluate and then what criteria should be adopted basing on the tender conditions, Lordship. This is very important. Basing on this, the evaluation was done. The rates, everything, Lordship's query will be answered by this.
Now,
Next
now,
page,
now
Lordship.
here it says quotes closest to the estimated amount. Now, what does 30 Roman 2 say?
31 Roman 2 says that
31 Roman 2 say.
page 39,
Page 40.
40. 31 2 says.
To be within the available bid capacity adjusted to account for his bid price, which is evaluated the lowest in any of the packages open earlier than the one under consideration. That is okay. In no case the contract shall be awarded to any bidder whose available bid capacity is less than the evaluated bid price.
Yes. Lordship, what happened is that I have referred to the decision which was taken on 13th September 2024. That was the criteria they have set. That is strictly in terms of the terms and conditions of the contract.
Where is that?
That,
Which contract term? Because otherwise I find this is in violation to 29.5. Whatever you were required to do, if he has not submitted, he has given a low rate, you have to take care of him, ask him what is the rate on which you are going to, how do you are going to propose to do it?
Lordship
You
is
fix
well
an
aware.
estimated rate very well, but once you fix that estimated rate, now if anybody is lower to that, you can very well reject. But you can, in no case, the contract shall be awarded to any bidder whose available bid capacity is less than the evaluated bid price. Even if the said bid is the lowest evaluated bid.
Lordship, that is why flag E will be very relevant.
Flag E, that is what I am reading, flag E. Flag E does not says about that you are going to give to the nearest.
Yes,
But where do you get the nearest permissibility?
because
Either
the
you have to give anybody who comes within the estimated price as per the contract,
yes,
or not at all.
Lordship, there are two bidders who have bid the lower rate. If we go by that rate, there will be compromise in the quality because
So therefore,
Ev- everything has been projected here.
understood, everything is understood, but why you have not taken action in terms of 29.5? 29.5 says that, gives you an opportunity what is required to be done. Doesn't it? If the bid of the successor is seriously unbalanced in relation to the engineer's estimate of the work, this is the estimate. The employer may require the bidder to produce detailed price analysis for any of the items of the bill of quantities to demonstrate the internal consistency of those prices with the construction matter and the schedule proposed. After evaluation of the price analysis, the employer may require the amount of the performance security set forth in clause 34 be increased at the expense of the successful so-and-so
Lordship, again,
to level are sufficient to protect. So you get yourself protected.
there is a saving clause in paragraph 32(1) also, Lordship. Can we come to that?
Yes.
Page 40. Notwithstanding clause 31, the employer reserved the right to accept or reject any bid and to cancel the bidding process and reject all bids at any time prior to award of contract without thereby incurring any liability to the affected bidder or bidders or any obligation to inform the affected bidders or bidders of the groups for the employer's action, Lordship.
There's no
So,
quarrel.
Lordship is well aware.
Mr. Jameen, there is no quarrel that you can reject or yeah. But if you reject, there has to be reasons. Otherwise, without reasons, it is arbitrary.
Lordship is well aware. Awarding the work to the lowest bidder cannot be the criteria also.
Absolutely.
There are so many decisions.
You may
Lordship
give it
is
to
given.
the third lowest bidder or seventh lowest bidder, whatever maybe you feel like you do it. But the fact that you are a state, therefore you are required
Lordship,
to meet the requirement.
Technical committee has been constituted and the technical committee has evaluated all the terms and conditions and then all the bids thoroughly. Now, the only contention which the petitioner is taking is, look, I am the lowest bidder. I stood at L1, so work should have been awarded to me. That is one. Secondly, as per the bid conditions, point 31.1, they have not complied with. But
31 point?
31.1. That is in page 39, Lordship.
What does it say?
Those are the conditions. Subject to clause 32, the employer will award the contract to the bidders whose bid has been determined to be substantially responsive to the bidder's document and who has offered the lowest evaluated bid price. So since he has quoted the lowest bid price, he should have been given. So that is the condition of the petitioner in the entire petition. Work order was issued on 28th of September 2024. 35% of the work has already been completed. Now, the writ petition was filed on 25th March 2025, after about 6 months. So Lordship, in this connection,
in
I have-
that connection is a different thing.
in this connection.
Fact that
Lordship,
you have given it to the respondent, but the pervert respondent illegally is another thing. But madam, why have you approved so late?
Lordship, in the meantime, we've been serving RTI as well as representation.
RTI? RTI won't help you. You should have immediately approached this court. After 6 months, if you have done it, then latches happens.
Lordship, on the basis of the order passed by this honorable court, I have so specific instructions from the director that if the project is delayed, what will be the consequences? And then what percentage of work has been done? They have done the photo, and then it was sent. Of course, it was through Google.
Madam said, you had a good case,
This will adversely affect the institution also.
but you have approached
Which
it.
will adversely affect the public
You
interest.
see, the powers of the court is limited. Only if there is a violation of Article 14. Now, Article 14, it is a it appears to be, but then also whatever happened is you have come way late. It is after all a contractual matter. You have allowed, you were sleeping. The principles of acquiescence will come in. This 6 months would not have been fatal if you were just an employee work. But here is a case where it's a contractual work. You had to be diligent. And going for RTA is not. You should have challenged it. I was R2. L2, if L3 has been given, why do you need an RTI for that? You'll be knowing it.
Lordship, the official.
The moment you are not got it, you see the price is open amongst all of you. In a contract, first the technical bid is done. Once the technical bid is successful, then they go for the price. The price is open amongst all, and it has been rejected. You were not given. So you knew it at that point of time that L2 was, you were L2 and he was L3. Now, if 34% of the work has already been done, and what is the period of the contract?
1 year, Lord.
So 1 year, and you would approach this court after 6 months.
And if there is no utilization certificate, work is not progressed, the bill will not be released. It will be released in 4 installments. That is on the assessment of the works progress. So I have just placed the
No,
instructions.
that is
which I
okay,
have
but
received from-
why we approach late?
Lordship, we've been received the final order only on 24th February 2025, Lordship.
You had a case, but I can't help it. I think we should dismiss it right now. Chalo, we dismiss. Because there is no point. Issuing notice, nothing is going to happen. Your main problem is delay. You had a good case. And give me that portion of paper which you have trying to place it before this court. With the photographs which you were showing. The 34% have been done.
Yes, 35%, Lord.
35.
It is shown as Assam since it was taken by Google. And then, but by looking at the altitude, latitude, in Google it will shown as Assam since it is near to Assam. But in the latitude, the longitude will show the exact location, Lordship.
How many story building?
3-story building.
3-story building, how can it be 35% with
Lordship,
only one flat has
Major
been done?
cost will go under the ground,
Huh?
which we cannot see also.
So that
Lordship is well aware, any construction, maximum cost is in the basement. Many things will go inside the ground, which we don't see.
how can you say it to be 31%? Only
And the
one.
top one is only just roofing, not a slab.
Hello. Madam, I'll issue a notice. I won't dismiss. Because this does not seem to resemble 35%. Have you looked into a 3-story building? Does it look 35%? Where there is only 1 story over the ground floor and 2 other floors are yet to be done. And the ground floor is still with bamboos.
First casting already done.
Chalo. Heard, mister? What to do? Dismiss?
Chief, at this stage, if the litigation lingers on, it will adversely affect the progress of the work also.
What is the difference between the amount both of you have given? How much has been given by number 3?
Number 3 also. Yes.
What is the difference in the amount?
215.
Huh?
Page 215. With petition.
215.
This document you had it then only 17th of September. Financial evaluation.
Lordship, this was produced only after 24th February 2024.
Why?
By the.
You could have been, these are e-tenders, it will be there everywhere.
Yes.
Then
Everything is there.
this must be there in the site,
Lordship, these are all.
in the portal.
Produced after the final order of the after appeal, Lordship.
The work order was issued on 18th September.
28.
Hello. Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. C.T. Jamid, assisted by
Correspondent number 2,
so-and-so,
3 and 4.
appears on behalf of the respondent number 2, 3, and 4. Mr. So-and-so appears for the respondent number 1. Full stop. Taking into account full stop. The instant writ petition is taken up for disposal at the motion stage. Full stop. The Director of Technical Education, Nagaland, who is the respondent number 3, had issued a notice inviting online bid. From eligible bidders registered under the Nagaland PWD Class 1 / CPWD / MES, meeting the eligibility criteria for the project, namely construction of girls' hostel at Government Polytechnic, Sethi-Kima, Desi Sumikidema, dated 28th of August 2024. Full stop. In terms with the said notice inviting online bid, the last date for submission of the bid was on 12/9/2024, and the technical bid was also to be opened on 12/9/2024. Full stop. In terms with the invitation for the bids, (IFB), it was categorically mentioned. Where's the period within which it is to be completed? Where is it?
Which point, Lordship?
Huh?
Which point?
Period within which it is to be completed.
Period of completion.
Hmm.
This is the work order.
No, no, no. Invitation for bid.
Page 19. Page 19.
Page 19. It is relevant to take note of that from the notice inviting online bid dated 28th of August 2024, it would be seen that the period of completion have been mentioned as 12 months. First of it is seen from the records, from a perusal of the petition, that various bidders submitted the bid, including the petitioner and the respondent number 5. 5, na?
Yes.
5. First, the said bid, the said bid, no, first, the technical evaluation of the bids were carried out on 16th of September 2024. And the petitioner, along with 2 others, the petitioner, the respondent number 5, along with another, were found to have were technically qualified, were adjudged as technically qualified. First, subsequent thereto, on 17th of September 2024, the financial evaluation was carried out. First, in terms of the said financial evaluation, it was found that the petitioner herein had quoted 10.13% below the tender value, and the respondent number 5 had quoted 0.09% below the tender value. In a said financial evaluation report, which was made on 17th of September 2024, the tender committee proposed that the respondent number 5 be awarded the contract. This was made, the said decision was taken on the basis of a meeting, of the technical committee held on 13/9/2024, whereby it was, give it to me, where is that? 13/9, the file is not here. 13/9/2024, whereby it was decided much prior to the opening of the technical bids as well as the financial bids, that the award of the contract shall be awarded to the firm of the company which scores closest to the estimated cost of the project. First, the resolutions were taken in the minutes of the technical evaluation committee meeting on 13/9/2024 being relevant is reproduced herein under. Madam, this, not the on top, the other one,
Page
just the
238 of the date petition, it is due also, Lordship.
not necessary. We put it here. I take this,
Yes, Lordship.
put it,
Lordship.
full stop. Is reproduced here. Full stop. During the course of the hearing, Mr. C.T. Jamid, the learned senior counsel, appearing on behalf of the respondent number 2, 3, and 4, have placed the said minutes, which is kept on record and marked with the letter X. On the basis of the decision taken on 17th of September 2025, 24, on 18th of September 2024, on the basis of the decision taken 17th of September 2024, the work order was issued to the respondent number 5 on 18/9/2024. This court further takes note of that after more than 6 months, the instant writ petition was filed, that is on 27, after more than 6 months from the issuance of the work order, the instant writ petition was filed, that is on 27/3/2025. This court further takes note of the submission of Mr. C.T. Jamid, the learned senior counsel, who submitted that in respect to the work in question, which was awarded to the respondent number 5, almost 35% of the work, there has been 35% physical progress of the work as on 1/4/2025. First, the learned counsel further submits that if the present litigation is allowed, the work would stop, which in effect would hamper the girl students for whose benefit the hospital has been constructed. First, this court had also heard the learned counsel appearing on behalf of the petitioner on the aspect pertaining to the delay and laches, in as much as the said aspect has relevance in more particularly in respect to a contract which is to be completed within a period of 12 months. First, it was only submitted that certain RTI, that the petitioner herein have sought information to the under the Right to Information Act 2025, 2005. Now?
Yes.
First, the said submission so does not appeal to this court, taking into consideration that the tender in question was an e-tender, and all the informations were duly available in the e-portal. First, this court have also taken note of a note being submitted by the director, the respondent number 2, along with the progress report and certain photographs of the constructions being carried out, which are collectively kept on record and marked with the letter Y. Taking into account that there has been delay and laches on the part of the petitioner to approach this court, and there has been substantial progress being made in the construction of the girls' hostel in question, it would not be proper it is the opinion of this court that it would not be proper to exercise the jurisdiction under Article 2 to 6 of the Constitution. Consequently, this court dismisses the instant writ petition. First.
For motion, item number 23.
What is this? Mr. Gupta? You are the counsel for that, no? What is your NIA? You are NIA counsel? No. Okay. Tell me, what are you challenging?
Your Lordship,
You want money?
yes, Your Lordship, the petitioner in the instant case is a government contractor. Higher technical education has issued supply order in favor of the petitioner. And for supplying of for the establishment of higher technical education and polytechnic. And all the materials were supplied and the completion certificate was also issued by the director of the technical education in the month of
Mr. Y.P. Gupta, the learned counsel appearing on behalf of the petitioner. Ms. So appears on behalf of the respondent number 1, 2, 3, 4, and 5. First, issue notice. Issue notice, making it returnable on when you are filing affidavit.
Your Lordship,
Well,
I'll try or after 4 weeks, Your Lordship.
okay. Issue notice, making it returnable on 19th of May 2025. First, taking into account that the respondent number 1 to 5 are duly represented, extra copies of so-and-so be served, of the writ petition be served upon Ms. So-and-so, who accepts notice on behalf of the said respondents. Next, the case of the petitioner herein is that the petitioner is aggrieved by the inaction on the part of the respondent authorities in making payment of the amount of rupees 35,99,998, which the petitioner is entitled to from the respondent authorities. It is the case of the petitioner that the petitioner was awarded a supply order amounting to rupees 35,99,998 for supply of various items. The petitioner duly made the supply, and in pursuance thereto, the Director of Technical Education had issued a completion certificate on 11th of March 2020.
yes.
Thereupon, the petitioner have been insisting the respondent authorities to make the payment, but however, for reasons best known, no payment have been made. It is under such circumstances the petitioner has approached this court. The respondents are directed to bring on record their stand as to why the petitioner would not be entitled to the reliefs as sought for in the instant petition. The affidavit be filed on or before the next date.
Much obliged, Your Lordship.
For admission, item number 1.
May I please, my lord?
Lordship,
Here, I'm yet to file affidavit, so can you grant me 1 week, Lordship?
you mentioned it last time also,
Yes, Lordship,
asking for 3 weeks.
yes. Now, we're pending for signature, Lordship.
Hello, we have it tomorrow. This is pending for signature. We file it today.
Lordship, the deponent is Deputy Commissioner Dimapur, so obtaining it today may be difficult.
What order is that? 310/2023? Yes, madam. As we have not filed a writ petition, take advantage of that.
Your Lordship,
Whereas on spot basis conducted by team officials from Dimapur and Niman, it is found that apart from the blockage of public drainage due to garbage in situation, various illegal encroachment in the form of construction over the land for public drainage have been detected. These illegal construction have resulted in obstructing the free flow of land. to prevent any impending disaster or further spread of dengue with expedient so and so. Therefore, what is wrong with this order?
Your Lordship, by this order, the petitioner was directed to demolish a portion of the building.
Absolutely, you are having it over
on the
drainage.
Allegation of encroachment of a public drainage, Your Lordship.
Is it your land?
Your Lordship, the petitioner has constructed an RCC building.
You construct RCC or a five-star hotel, that is your lookout.
In the
But is it in your
United States,
land?
Lordship.
Is it in your land? Above the drain? What is he asking? This is a serious thing. How can there be a stay? Whereas to prevent any impending disaster or further spread of dengue cases, it is expedient to order demolition and removal of structures and buildings that have come over the public drainage. Now, therefore, in the interest of public service, in so and so, is directed to demolish and remove that portion of the building and structures that have encroached and or above the public drainage within a period of 5 days. Failure to do so is so and so, 45 square feet only. How can you have a drainage over here?
Your
No,
Lordship,
no. This type of matters cannot happen.
uh,
What is your instruction? Show me whatever you have got instruction. Finish it up. Unless this type of matters cannot remain. You don't require an affidavit. How can they be? No, they can demolish by making verification as to how much, if it is, you have already verified.
Lordship.
So then nothing remains. You cannot have it over the drainage. Yes. This type of how are you conscious citizens above drainage? You see, in Nagaland and Kohima, they have made such beautiful drains which we don't have it in Gauhati. And it is kept very clean and spank out here. And you are there in Dimapur disturbing the ecological outflow of the water.
Lordship, the construction was built over my land. There is no encroachment at all. Even if there is encroachment, there is a provision under Nagaland Eviction from Unauthorized Occupation Act to serve notice to the person, giving 15 days time. However, Lordship, in this case, the respondent authorities invoke.
You wanted 15 days time.
No, Lordship, that is the.
You want that 15 days time to be given by the Nagaland authorities. It is the land which belongs to them.
No, Lordship.
Then the land belongs to you.
Yes.
Prove it before the civil court. Go there. Well, how
No,
can
it-
we
it is
decide
not
that
me.
whether
You are
it is?
disputing that
No,
I've encroached,
no,
Lordship.
Mr. Counsel, how can we decide that you have encroached or not? Tell me, give us a good idea.
I've enclosed the
I am
allotment
also
order, Lordship.
wanting to find out
Lordship,
how
kindly consider.
in the writ proceedings this
No,
court is going to do that.
You are disputing. Otherwise, I've constructed my house over the allotted land.
You construct your house over the allotted land, fine. But this is the area of 45 square feet. Now, whether it falls within your land or not, go before the civil court. Go before the civil court. This is not a court. How can this court decide on this aspect? Tell me.
Lordship, if there is any verification conducted, opportunity has to be given to the petitioner, Lordship. No opportunity, nothing.
Verify in his presence and go ahead. I know. Simple.
I was the call for verification,
You see,
Lordship.
keeping this matter pending will only lead to dengue. Okay. So I give you the permission. Go and make a verification, and if it is found, whatever it is, in his presence on a particular date,
Lordship,
Lordship, if
it is already verified, Lordship.
understood, let
Yes.
him be satisfied. And then the moment you find it outside, demolish it. Go ahead.
Lordship,
He is normally to go before the civil court. If it is the area between your and the government land, you should have gone to the Supreme Court.
Lordship,
Why should we?
if the authority requires my land, I'm
This
willing
is
to
the
part with
case-
my land,
This is
Lordship.
the case
However,
where
there should be
action is,
process.
Mr. Counsel, this is the case where action is being taken under the Disaster Management Act. So under this provision, this action can be very well taken in order for removing all this the problems which may cause dengue. This is not a case of public premises thing. This is a case under this provision has been rightly invoked. Yes. You are verified to go before the civil court and prove that this 45 square feet is yours. Not this writ court. Did we go there and then measure? How will I do that? That whether you have a constructed on the road or not. They have stated that it is the road belongs to this area is the public drainage area. Your case is what? Yes, there's no question that there's no denial that there is no drain. Yes, there is a drain, but the drain has become bigger.
Lordship,
The drain has become bigger during the
No.
course of the time. Although the drain was marked for a particular area, but the drain has now changed its course nearby your land. That is your stand.
Lordship.
Then. So they will make a measurement of your land, how much it is. And if it is outside, they'll throw you out. Isn't it, Mr. Ahmed? Instead of keeping this matter pending out here, the conscience of
Actually,
the court-
Lordship, whatever is,
the
I'm willing
conscience
to,
of the court does not permit this type of actions. One has to also think about the public interest. Thank you. Chalo. We keep this on record and mark it with a letter. Have spot verification reports also. His land, all these things are there. This is being placed before this. Chalo. Heard Mr. So-and-so, the land counsel appearing on behalf of the petitioner. And Mr. K. Angami, the land counsel appearing on behalf of the respondent numbers 1, 2, 3, and 4.
Yes.
Full stop. The present petition, the present petition has been filed by invoking the jurisdiction, invoking Article 2 to 6 of the Constitution, challenging the order dated 3/10/2023, whereby the respondent number 4 had passed an order, thereby directing the petitioner to remove the encroachment over the public drainage within a period of 5 days from the date of passing of the said order, or else there would be forceful demolition and penal action against the petitioner. First, this court have duly perused the said order dated 3rd of October 2023, wherein it has been mentioned that after spot verification conducted by a team of officials from the Dimapur Land and Records Survey Office DMC, Urban Development Department and District Administration, it is found that apart from the blockage of the public drainage due to garbage and siltation, various illegal encroachment in the form of construction of buildings over the land reserved for public drainage was detected. Full stop. In that regard, it was also found that the petitioner had encroached an area of 45 square feet.
This is the. Actually, it is 201 square feet area. That is a spot verification report. The photograph is on the back side.
That I have it. This document, I have it here. But why you are saying more than that? It may be noted on verification the width of the road per measurement in the map is 14 feet and the drainage encroached is aerial in nature, measuring an area of 3.8 by 53 feet. Now, we are only concerned with 45 feet. Let us not go into this. Because found that the petitioner have encroached an area of 45 square feet. The case of the petitioner herein is that the petitioner was allotted how much? 15 lechas. Mr. Council?
Yes, sir.
15 lechas of land at Dimapur town. The petitioner's husband was allotted 15 lechas of land at Dimapur town. And the name of the petitioner's husband was duly recorded in the Patta number 607, Dag number 804, block number 4 under Dimapur Moja number 2. The petitioner thereupon had constructed a commercial RCC building in the year 1980. The petitioner's husband,
Yes, sir.
husband had constructed a commercial RCC building in the year 1980 within the Patta land. It was mentioned that at the time of constructing the building in the year 1980, there was a small drainage adjacent to the allotted plot. It was also mentioned that in view of the development of the town and the increase in the population, the drainage had expanded. The drain had the size of the drain, the breadth of the drain, the width of the drain had expanded by erosion and thereby touching the very foundation of the petitioner's building. It is therefore the case of the petitioner that without proper verification, the order dated 3/10/2023 was passed, which is impugned in the instant proceedings. First, it is seen that no affidavit has been filed by the respondent authorities in spite of notice having been issued in far back as on the year 2023. So taking into account that the matter pertains to taking into account that the matter relates to public injury being caused, taking into account that if any delay in the disposal of the instant writ petition may result in public injury. This court took up the matter and Mr. K. Andami, appearing on behalf of the respondent number 1 to 4, had also placed before this court the instructions he received in the year October 2024. The same have been kept on record and marked with the letter X. For a perusal of the said instructions, it has been mentioned that there was a verification committee which was duly constituted. And the said verification committee, after making the thorough verification, found that the area encroached by the petitioner's late husband measures approximately 45 square feet. It was also mentioned that due to declaration of dengue as an epidemic in Dimapur, an urgent intervention was required to mitigate the disaster. Therefore, apart from the National Disaster Act, the respondents have also invoked the powers under Section 133 CRPC of the Code of Criminal Procedure 1973, which presently corresponds to Section 152 of the Bharatiya Nyaya, whatever, BNSS full name, 2023. First, it was also mentioned that the order dated 3/10/2023 was required to be passed for the interest of the public. This court have also taken note of the verifications which have been carried out, reports which have been submitted, wherein it has been mentioned that there has been a drainage encroachment by the petitioner, by the petitioner, of an area of 45 square feet. Mr. It is also seen during the course of the hearing, it is also seen from the records that on 3rd of November 2023, the Extra Assistant Commissioner bracket REV bracket close Office of the Deputy Commissioner Dimapur had also submitted a spot verification report in respect of patta number 607, dag number 808 at block number 4, that is date, From the said patta number, it appears, from the said spot verification, which was carried out on 20/10/2023, it appears that there has been a further, that the encroachment made is more than the 45 square feet, in as much as it had measured 3.8 feet into 53 feet, which corresponds to 201 square feet. The same document, which was placed before this court earlier, dated 3/11/2023, is kept on record and marked with the letter Y. This court, having given an anxious consideration to the materials on record as well as the submissions made by the learned counsel for the party, is of the opinion that the grievance made by the grievance of the petitioner is that these verifications were carried out behind the back of the petitioner. This court cannot turn a Nelson eye to the fact that that blockage of the public drains would lead to blockage of the public drainage system has disastrous consequences on the public safety as well as public health. First, considering the above, this court disposes of the incident petition with the following observations and directions. First, the respondent number 4 herein is directed to carry out a fresh verification as regards the verification as to whether the petitioner herein have encroached upon the public drain. First, the said verification be carried out on, give me a date, on 21st, 22nd, 23rd of April, 23rd of April. Okay. 23rd of April. On 23rd of April 2025. The petitioner hearing at 25 at 10:30 AM. The petitioner be present, is likely to be present during the course of the said verification. In that view of the matter, there would be no requirement of issuance of any fresh notice by the authorities to the petitioner. This court, number B, this court further directs that after making the verification, if it is found that there is any encroachment by the petitioner over the public drain, the authorities would be at liberty to take due action as envisaged in the law.
Lordship, beyond ordering given depends still the outcome of the verification. Lordship.
Not necessary. I've done them. No, why they will do anything?
No, Lordship. Otherwise, Lordship, the authorities will carry out the eviction in terms of the impugned order.
If they do with the impugned order, you should be happy. Only 45 goes. If they go for a fresh verification, they will take you 201. In fact, you should have been very happy with 45.
For admission, item number 2.
Now, just one line. It is further observed and directed that till the verification is being conducted as directed here in above, no course of measures be taken upon the petitioner. Yes, what is this? Interim order. Why is this so big?
Lordship, I'm yet to find my reply. I've prepared and sent for waiting. So I should go to the meeting.
You filed to reply on 12/3/2023. You sought for time.
Yes, Lordship, we haven't filed yet. I've
Fantastic.
sent for waiting.
We do one thing, we vacate the interim order and fix it and adjourn the matter, sign it out.
Lordship, just a week.
We adjourn the matter, sign it out. Don't worry, it won't come. You don't need to file the affidavit. We'll vacate the interim order. What do you say, madam?
If 1 week is requesting to be fair, then the Lordship 1 week may be granted.
Earlier also, you see how many times he has, how many times, let me
We
tell
were
you.
beginning debate to obtain a certain document.
Wait, 17/1/2025. Council appearing for the petitioner prays for 3 weeks to file affidavit in reply.
The institute is in our ground, so. we will take time.
10/2/2025, the petitioner prays for 2 weeks. Then 25/2/2025, appears for 2 weeks. Then he finds the youngest of our judges, Madam Longkuma, being here. So she takes the advantage and takes another 3 weeks. And being a new judge, she also thought that why should I disappoint her, and makes it 3 weeks. And now you have come back to an old judge. So how will I allow it?
Lordship definitely not taking.
No, don't worry. Adjourn it, sign it there. Don't need to file. Where's the interim order? Let us see that interim. We need to vacate it. What is this interim?
2/11/23.
Till that impugn circulars. What are these circulars, madam?
Is directing them to undergo DLED training.
My
They are not
goodness.
teachers. So
Yeah.
we have directed them, they approach this school.
So they are teachers.
Yes, Hindi teachers. We have served for almost 10 to 20 years and
So you
most of
don't
us
want,
were.
so you don't want to take.
No, Lordship, we are not eligible for the course now. We're almost reached 40 plus and 40 years. And back then our qualification, required qualification was just +8 pass. And
So you now want to make it 45 with the pendency of the petition asking for time for it. Something like that.
Lordship, just 1 week maybe.
Huh?
Just,
Okay, we give you with a cost of 10,000.
no.
No, cost has to be given. The hook. The council appearing on behalf of the petitioner seeks for a further accommodation for filing a reply to the affidavit in opposition. Full stop. This court have duly taken note of that the petitioner herein is enjoying an interim order. Full stop. The reply, the affidavit in opposition has been filed prior to 31/8
24.
24. And thereafter, for almost 8 months, time has been taken whenever the matter has been reached, seeking for filing the affidavit in reply. Today also, the time has been sought for. And on the other hand, there is an interim order operating whereby the respondent, the certain circulars have been stayed. Taking into account the above, this court grants a last and final opportunity to file the affidavit on or before next week. Okay, with a cost of 10,000. On or before 11th of April 2025. The sale is being done subject to imposition of a cost of 10,000 upon the petitioner, which has to be deposited on the next stage, along with the acceptance of the reply shall be subject. Will be the deposit of rupees 10,000 shall be a condition precedent for acceptance of the reply.
For admission, item
Interim
number 3.
order passed earlier shall continue till the next date. Yes, what is this?
Lordship has filed my affidavit during the course of the day, Your Lordship. And moreover, Your Lordship, state has filed a writ appeal number 234 of 2025, which will cover this case, Your Lordship.
What is the matter about?
This is identical to the matter which was taken up yesterday before the division bench, that regularization.
So you need to file an additional affidavit.
Here I have annex 2004.
No, have you taken that ground? It's a different thing. Have you taken that ground which I said to you yesterday? No.
I'll have to check it out, Lordship.
You are still on 2015. 2015, you don't come.
Yes, Lordship, I am on 2004 as well as on 2000.
So let us dismiss as per what today I am sitting in single. So I am bound by Justice Sema's order. Don't you think that?
Your Lordship,
So shouldn't I dismiss his petition on the basis of that? But you need to file a reply. Let him file a reply. You have not taken that ground. 2015, you don't, I am not covered.
There is already a division bench decision.
That decision would not help you. You don't come under 2015. You retired. Thereafter, you woke up.
In paragraph 7, Lordship, I have. In paragraph 7.
What did you
I have
say?
taken. I stand on 2004 notification, Lordship.
What do you say? Came into existence in Iman.
In paragraph 8, also I have given a chart, Lordship, wherein employees who are much renewed to me, Lordship.
6 years have also become. And when were you appointed?
I was appointed, Lordship.
All these were junior to you?
Yes, Lordship, from 21 to 1982, Lordship.
All these are junior to you have been appointed?
Who regularized, Lordship.
Okay. Ms. So-and-so appearing on behalf of the respondent submits that affidavit would be filed when?
Today, Your Lordship.
During the course of the day. So taking into account the above, list this matter again on 6th of May 2025. In the meantime, the petitioner would be at liberty to file the reply as advised.
For admission, item number 4.
Notice, Your Lordship.
Yes.
I believe this matter will be disturbed next week.
What?
And the council taking up this matter is in this post.
Indisposed? Why the matter has come up?
It's for admission,
Hearing, so we should carry out the hearing. What is the matter about challenge?
Lordship here, the petitioner is seeking for appointment on the basis of membership.
Oh,
Over the compensated land,
huh?
over the compensated land,
Oh, he has been compensated.
3 lakhs, within many, many.
Lordship,
Then-
however,
Then you have that circular, na?
Yes.
Has that have the petition undergone that circular?
Lordship, however, in the agreement, they have clearly stated that even after giving tribute, they will give an give purpose. If you see the agreement, there's a written agreement.
So do you admit to the agreement?
Supposedly, this is an undertaking by the landowner himself.
Lordship,
It's not an agreement.
the state government, they have filed their affidavit stating that this is an agreement. By order dated,
Who are you?
I'm for the legal department.
Lordship, by
I did
order,
not file lordship. That was filed by the Deputy Commissioner.
Lordship, by order dated 3/2025. The
Affidavit
the
of the
course-
respondent number 1, 2, and 4. What does it say?
respondent number 3 has filed stating that.
Who is 1, 2, and 4?
Respondent number 1, 2, and 4.
Ah.
Is the state of Nagaland represented by the.
I'm for 1, 2, and 4.
Okay, so your case is that you were not a part of that agreement.
No,
It was done by the DC.
this. So lordship, if you go by the agreement itself, the word agreement has been used, lordship. But if you see the.
You
context,
have also used that.
lordship,
You have also used it. Kindly come to your affidavit at page 9.
my affidavit.
1, 2, and 5, na?
Yes,
Kindly page 9. What do you see in paragraph number 2? Are you not
the
also?
agreement, salary MOUs.
So you have gone for agreement, sale deed, everything. Then you all by yourself have said that it to be an ignored. That is the besides the point. The question is out here is that who is to give the land ownership here? Is it the office of the deputy commissioner or is it the medical department or the veterinary?
But he's seeking employment other by department.
So can it be given as per the land ownership program? You have a particular circular, na?
Yes, lord.
Where is the circular?
Lordship, that is at page 70 of the review law. Page 70.
No. Definition is not that.
So this is the letter of.
Page 70.
70. Type page 70. Original at page 68.
Let us go by the type copy. And the why then
Lordship, I can come to 3A.
quite free of
3A will be rid of lordship.
3A. In other cases.
I'll be not doing so.
subsequent settling of the
In other cases prior to 2026-7/5 and subsequent to setting up of administrative and block headquarter on freely donated land. Lordship, this is very important, on freely donated land. Where a specific written agreement exists providing for employment to the landowners, the claim of the landowner for employment should be settled in terms of such agreement. This is speaking about freely donated land. Freely donated land. If there's an agreement, then such agreement has to be adhered to.
freely donated land.
Yes. Now, Lordship,
So
coming
if
to-
money is taken, then nothing.
No. Then coming to their own document, Lordship, annexure 1A. Lordship, if I see,
Wait. Yes, madam. So I'm going to dismiss your petition. No.
It's really
No,
donated land, however.
no, madam,
There is a written
wait. I will dismiss your petition, so therefore I don't want to dismiss it in your hands. Where is your senior?
And-
Where is your senior? there. So that he has taken advantage. Now he's there, so in front, I'll dismiss it with him. Yes.
Your Lordship,
Really,
this is not the only department that has given appointment after making some payments, Your Lordship.
but that is not you are claiming on the basis of a policy. The policy says freely donated land.
Oh, Your Lordship, even on the premise of where there is no written agreement also, Your Lordship.
So then then you have to go under 3B.
No, Your Lordship.
You have to go under 3B.
Even assuming that we do not go into the policy, still.
Then nothing.
Yes, Your Lordship. No, still there was a written agreement.
Then nothing. Mr. Sikhi, the question of getting an employment on landowner basis is absolutely on the basis of the policy. On the basis of agreement, they cannot be. Otherwise, it will have a chaotic out there rule of law, and nothing will remain. Every director will come up out there and come up, okay, let me have an agreement with so and give an appointment. You'll have serious consequences. So, now you're the right person to dismiss. Okay.
My Lord, we also very appreciate this respect. I know my Lord's mind is already made up.
No, it's not made up. At the moment I make up my mind, therefore I have asked her to. I asked her, but the moment senior was not there.
No, actually, my other junior is handling this matter. I've entrusted some matters to my juniors.
Okay.
So the other junior is handling the matter, is absent today, so she was trying to take time. My Lord.
So therefore, I was also not trying to dismiss it in her hands.
Hello.
Therefore, I'm now trying to dismiss it in your hands.
My Lord, this agreement was executed way back in 1994.
But it is with money. 94, how much land did you give?
The area is 130 into 200 feet. So in square feet, it will be very large, Your Lordship. I'm not very good with mathematics, but.
How much area?
130 feet on one side and 200 feet on the other side. So it's.
So it will be 2,000.
It
will be how much? 26,000 square feet. Huh? 26,000 square feet. 26,000 square feet will be how much?
Less than 2 bigas.
Huh?
Less than 2 bigas. Less than 2 bigas.
Because less than 2 bigas. I think 14,400 is 1 biga.
Yes.
So it will be 2 is 28,000. So it is less than that. So you got 3 lakhs. Where is that?
Huge one.
Huge.
1994, Lordship. 1994.
1994.
Can you imagine that amount?
You should return that amount, some amount.
Perhaps, Your Lordship, the amount of compensation given and the assurance, Your Lordship, since it goes together, the amount is not to be discussed. Your Lordship. In any case, Your Lordship, we kindly appreciate this. There were several vacancies even before the 2015 OM, Your Lordship. And all these vacancies have been filled up on compassionate ground. This is the third vacancy that has come up over the years. And this agreement it was never realized in the function, Your Lordship.
Then?
Lord, the first vacancy arose on 16/8/1994. That was also not given to the petitioner's family. Second vacancy arose in 1999.
After taking 3 lakhs. Did you apply in 1994 on landowner basis?
I do not know, Your Lordship.
So,
According to the
Anyways,
information that I received, it
anyways.
was applied to your lordship.
Anyways, it is 1 o'clock now. You have been able to save your time till 1 o'clock. So the second half, I only would be taking up
At
matters.
least a short time will be granted so that because I have not gone through the petition also properly.
Not necessary. Not necessary to for giving you time, but 2 o'clock onwards, I'll be taking up matters where both the councils wants the matter to be taken. As you have some meeting out there, anybody who wants some matter, because if it is a case of some appeal or anything where there is urgency, I'll take it up. And you have escaped a dismissal today.
Also, let me have the liberty of till tomorrow.
Huh?
Till tomorrow.
Which one?
Since he is mentioning that he has not gone through the brief, so he can take the whole night to go through the brief and then he can argue tomorrow.
My little friend is very kind to lordship.
Okay. Mr. J. Saki submits that he has to go through the writ petition to start taking into account the above. At the request of matters that is going to be taken up tomorrow at 2 p.m.
Past years, actually, about 20 years, that much more, that.
something which will be said.
Speaker, let me do that back. Who is there for other side? You are there. What are you challenging?
Lordship, I'm challenging certain notifications, Lordship. This is a promotion case, Lordship. The petitioner is serving as an associate professor and one of the in Kohima Science College. He's a government employee, Lordship. He's been serving the department for the last 17 years. Now, what has happened in this case is that, Lordship, he was found to be eligible. He was screened. He was found to be eligible. Then, in the result, prepared by the expert committee, as per the service rule, they said that the result is valid for 1 year. Because unlike other department, Lordship, this is a post or promotion to the post of principal, Lordship. Now, unlike other department, there is no seniority list maintained. So what the department is doing is that, as and when vacancy arises or anticipated vacancies are there, they advertise, they call for eligible persons, Lordship, to come and then if they're found qualified, that they are promoted. In the case of the petitioner, he's aggrieved, Lordship, because the assessment committee, as per the service rule, they said they put it in merit list 5. Their Lordship, and the analysis, the result is valid for 1 year, Lordship. Now, during the time that happened on 17 August 2023. Now, what happened was those 3 persons from merit list 1 to 3 were accommodated, given officiating promotion to the principal, post of the principal. Now, during the period when the 1 year validity was still valid, 2 more anticipated post vacancy arose. So the department on 29th of April 2024 recommended petitioner and along with the person who was put in serial number 4, seeing that they are found to be eligible and then recommended to be promoted to the post of principal. Now they said, see, in that letter, Lordship, the director has written, and then in that letter, it is specifically written, Lordship, that since the result is valid for 1 year, so they are found to be eligible and recommended to be promoted. Thereafter, vigilance clearance was also sought. But then again, the director has, in contrast, issued a notification, advertisement on, he has came up with a letter saying that the government is not accepting the waiting period of 6 months, 1 year. And the waiting period is what is accepted by the NPAC, National Public Service Commission, is 6 months. So he has cancelled it. And on the next date, a circular was brought. Then on the same day, advertisement was issued. Now, during the pendency, the petitioner also approached the department because here at the time when they were screened and interviewed, Lordship, they were clearly told that as and when anticipated vacancy arises during the time the result is valid, they will be accommodated. But then again, now they agree, please agree, because how can the director, who has no power given by the service rule, Lordship, supersede or cancel the decision of the expert committee?
So you were appointed in 2006 as a lecturer.
Yes, Lordship, through proper channel, through NPAC, Lordship. In fact, I was selected in the year 2004, but then there were issues arose with the contractual employees, Lordship. Then we were given backdated appointment.
So
Not backdated.
This was an advertisement issued on 24th of May 2020.
Lordship, yes, Lordship.
Whereby applications were invited from eligible AR from government college for appointment to the post of principal in the academic level of so and so. Last date of so and so. Then notification is issued on 8th of Iman on recommendation of the selection committee. And as per the demand of following, how many posts were available?
Lordship, there is no mention, Lordship, in the
The
advertisement.
post of principal in the academic leader. Huh? How many posts? This advertisement was for 3 posts.
Yes, for three.
How do you know?
Lordship, because the recommendation and the selection was done for three posts.
On recommendation of the so-and-so, the following candidates who so-and-so were found to be the posts are hereby informed shall be held on demand in the conference hall. So everybody has been given. Then comes this interview assessment. So the petitioner is in the wait list, number
Lordship,
3.
yes.
So
Lordship,
3
yes.
were recommended.
Lordship.
Then in the interest of public service, the post of principals and posted at the colleges mentioned against their names under the higher education category. So. These are Annexure 6 are the appointment notification.
Lordship, yes. You were given officially promotion.
Then
Merit from the one to
submitting a proposal for appointment of principal
Which
to
was 6.
anticipated retirement vacancies in May and June. Now, under what rules are these made? Under what rules are these made?
Lordship, the appointment is made under the rule 2015.
You have a rule?
Yeah, in fact, the petitioner annexed it in the petition itself. The Lordship will find it at page 15, starting from page 58.
These are Nagaland Higher Education Service Rules.
Lordship.
Direct recruit. This is a case of direct recruit or promotion?
Promotion.
Promotion, Lordship.
Promotion.
Under the career advancement scheme, Lordship. In fact, the service rule is silent on the criteria for promotion to the post of principal, Lordship.
Okay, but promotion.
Lordship, relevant.
But the advertisement is not for promotion. Annexure 3 is not a promotional for appointment to the post of principal in here. You are asking from anybody.
No, Lordship. Only from among the for this government eligible candidate in government colleges.
Understood.
Yes.
So anybody who is there
Yes.
can fill up the post of principal.
If the qualified.
He has a history to be from eligible candidates in government colleges.
Yes, yes.
So directed that promotion. Promotion, then where is the promotion thing? Promotion, direct recruit.
Lordship, rule 12. Rule 12, page 66 and 67, Lordship.
Before the list of eligible, before the DPC, so shall very assess the fitness of the demand. Fitment shall be the list of eligible to be considered for the placing in the register. So contain this tree on the number of vacancies in the case of the person. But where is the question of the select list being valid?
Lordship, if you see the result, Lordship, it is there, Lordship, page 44. There below, Lordship, it clearly states that this certified that the candidate recommended and selected will be valid for 1 year.
Where page?
Page 44, Lordship.
No. How can you say that? It's a promotional post.
No, Lordship,
No,
and
you see, if it is a promotion,
yes,
then how can there be a validity of a 1 year? Unless the rules provide.
Lordship, that is the terms set up by the government, Lordship.
No,
and the
the
department.
government cannot do anything which is not there in the rules unless there is a notification to the effect. Where is the notification? There has to be an executive instruction that whenever there is a select list, it will be valid for more than a year or for a year. Where is that?
Lordship, there is no such notification. But if you see the letter dated, Lordship, page number 46.
Understood. He cannot do that. It has to be done under 166(1), 166(2), Article 166. Then how did? Because these are rules under 309. The 309, wherever there is nothing mentioned out there, it can be very well supplemented that the select list will be valid for 1 year. But where is that notification? Merely writing by somebody would not help.
Lordship,
Because
there is no notification, and it is also not the fault of the petitioner, Lordship.
I understand, but the fact remains out there, the normal practice follows it. Once the three posts were filled up, then it has already exhausted. That is why I asked him, how many posts were there in the advertisement? Is it for all principals? Because otherwise what will happen? Because you are having for merit on seniority. Merit, it is not seniority on merit. It's merit cum seniority, where the merit will have a predominance over the seniority. If the merit is equal, then the seniority comes into the picture.
Yes, Lordship.
So therefore, whatever may be have been given out here, this is the marks which have been given. Now, you see those persons who have got 61, 67. Now, this person who have got 67, they have been recommended. Okay. Now, your person has got number 5, have got 50. 50. But if you are, then you have been only given on the basis of seniority. The seniority cannot count. In fact, this recommendation is also wrong. Isn't it? Tell me. Madam, read one of the very nice judgments of the Supreme Court. I give you this. They have a lot of time. There's no work. Only you and him. It's a nice judgment. Beautifully written by Justice Pardiwala, recent judgment, 2024 SCC Online, SC 972. Okay. So, here is the question of if it is promotion, then it is merit cum seniority. If it is a merit cum seniority, what is the requirement is that the merit will have predominance. If it is merit has to have predominance, then if there's merit which out here, the petitioner has got number 50, only 50.
Correct.
He cannot be at number 4.
Correct, Your Lordship. Your Lordship, not only this, Your Lordship. The case of the petitioner is this, Your Lordship. He, after this interview was conducted, which my letter has just read out, selection has already been done, and he was kept on the waiting list. Now, Your Lordship, the waiting list right of an appointment of the person whose names are in the waiting list will accrue only when the selected candidates, either of them, either decline to accept the appointment or for any reason resign from the post. Only then.
No, resignation also does not arise.
Yes.
If they decline for the appointment.
Yes.
Because if he resign, it is a creation of a new post.
Correct. Now here, the list which was prepared where the name of the petitioner was in the waiting list, the recommended candidate has already accepted their appointment, and there is no vacancy thereafter. What happened thereafter, Your Lordship? There was some subsequent vacancy that arose. Advertisement was again issued, Your Lordship. The petitioner pursuant to the second advertisement appeared to interview again, Your Lordship. And thereafter, again, he did not manage to clear. And then after appearing the interview, Your Lordship, the petitioner is here before this court challenging the very advertisement, Your Lordship.
The secondness, the second.
Yes, correct, Your Lordship. That is that permissible under law, Your Lordship. That is the only question that they need to be
So
addressed.
there is a stay,
There was a stay, Your Lordship, earlier. There was a stay.
now stay vacated.
Stay has been vacated, Your Lordship. Stay has been vacated. But the issue is this, Your Lordship. They
No,
pay-
issue is this means that select list is already exhausted unless by way of a statute, by the statutory rules, that a waitlisting candidate comes.
Correct. Even in some of the judgment that has been passed by the apex court, in case of exigency or emergency, if the government can, by framing a policy, the government can appoint somebody who is in a waiting list. But that is very limited for very limited purpose.
And not only that, the aspect pertaining to this is, you see, for example, this person, Dr. Daniel Kimami,
Lordship.
this person should have been number one. Number two should be Dr. Nibito B. Kutso. He should be number two. They have been put at waitlist number 4, 5, 7.
Lordship.
This is wrong.
Lordship.
If they have come out, this
Yes.
select list would have gone.
Merit comes,
Huh?
seniority.
Merit comes seniority.
Lordship, in fact, there is no clarity. There is no clarity in the service rule. That's why the confusion are arising. So the petitioner is also aggrieved because in a paragraph, Lordship, the petitioner is also seeking the indulgence of this court, Lordship. If a direction might be issued because as per the service rule, the procedure for appointment to the post of principal, nothing is mentioned, Lordship.
No, they say, no, it is already mentioned of how it will be. From these rules, it can make out that what are the things will be required. A list of eligible candidates will be considered for promotion. The list shall contain the API and PBS in respect to all the officers in the list, the representation of the individuals, if any, against adverse entries, integrity character certificate together with vigilance. Then, on receipt of the documents specified in sub-rule 1 by the Commission and after such clarification as may be required, the committee shall meet and prepare based on the principle of merit cum seniority a select list of officers in order of preference equal to the number of vacancies or anticipated vacancies to be filled by the promotion during the recruitment year. Now, therefore, in this case, the vacancies which arose for the purpose of that selection
Lordship.
was all the vacancies, which was only 3.
Correct, Lordship.
And two were,
And the
two were
3 had been
anticipated.
filled up.
Yes, absolutely.
Lordship, two were anticipated. That's why
And that was a
proposal dated,
Lordship.
proposal letter dated
Yeah.
29 April.
And 2, if it were filled up, those 2 at 8 and 9 should have got it. Because this is absolutely wrong. How is it possible when it is merit cum seniority? It means the person who is meritorious, you are giving him you are putting him, sadly for him, he's still languishing as a lecturer.
Associate professor.
Huh?
Associate professor.
But the only issue, Your Lordship, here is, can a person who has appeared the interview, after appearing the interview, can a person come and challenge the same advertisement? That is the issue, Your Lordship. Can you allow me to take my Lordship to the prayer portion? Your Lordship, I've already seen it.
Yes.
Yes, Your Lordship. The prayer, Your Lordship, of the petitioner, Your Lordship will find it at page 34.
Yes.
Lordship. A, Lordship A, B. Question set aside the impugned letter, 3rd of June 2024, under the subject submitting a proposal for appointment of principals and requesting for administrative approval for advertising and conduct of screening for appointment of principal. B, was and said the impugned tribunal dated 4 June 2023 as ultra-virus and arbitrary. D. Was and said aside the impugned letter dated Kohima, the 4th of June 2024 under the caption advertisement for the post of principals as long. E. Was and set aside the impugned notifications dated 19th June 2025.
Where are those?
Your Lordship will find those starting from, Your Lordship, page 51.
51 is the circular.
Yeah, page 50, madam. Page 50. This is a letter written by the director to the government, submitting a proposal for appointment of principals.
Then where's the advertisement?
Advertisement, Your Lordship will find it at page 52.
So this is the advertisement on the basis of which the petition appeared the second time.
Second time, Your Lordship. Second time.
And there what happened?
Your Lordship, thereafter, again by notification 19 June 2024, which Your Lordship will find at page 54. He was selected to appear for the oral interview, Your Lordship, to be held on 24th of June 2024.
Okay, no, this is okay.
Yes.
This he did not fare well here,
Yes.
but the earlier was in respect of another one, no?
Yes.
And
This is
also,
what
there's
it is.
no law barring him from
No,
appearing,
no,
Lordship.
can appear.
Lordship, so since the case of the petitioner is that when the select committee has recommended the result to be valid for 1 year, and the proposal was given, Lordship, telling that he is eligible, and then recommended, Lordship, right? Letter dated in 9, Lordship. Then the vigilance clearance was sought. Lordship, so
Madam, if that letter from the Director of Technical Education, if it was in Assam, it would have been a scam.
Lordship, yes. Lordship, yes. It is not in line with UGC guideline, Lordship. It's not in line with UGC guideline. No, that is why, Lordship, now the grievance of the petitioner is that how long must this continue? Because there is no clarity.
No, the clarity is there. First of all, they have made that mistake. In fact, there is no mistake. You did not get the that select list which was there. Sadly, those people who were in 8 and 9 should have got it. But the thing is, you under no circumstances could have got it. You got only 50.
Lordship, yes.
It's merit cum seniority. You could not have got anything more than that. So you should have been down below much. You should have been the last.
Yes.
There were 3 vacancies out there. And against these 3 vacancies which are there, these were filled up.
Lordship.
Once the filled up, the select list has been exhausted. Once it's exhausted, you cannot appoint unless by the rules or by way of an executive instruction. It is being done. It being not done, nothing happens. Now you cannot, after a fresh advertisement have been issued, you participate in that advertisement, you do not fare well, again come back and challenge the advertisement because you were there in that post. Madan Lal jumps into the picture.
Correct.
Lordship, yes.
So why on earth did you today appear before me to get a dismissal?
Lordship, yes, it's also.
No, Your Lordship, in fact, we both my elder friend here and myself were waiting for this court.
Lordship.
We tried another court, but unfortunately we could not get an order.
Lordship, yes. So, Lordship, it is also the desire of the petitioner that to.
You still have the
any
age.
hearing, Lordship.
No, it's okay, but I'll pass the order just now. You have the age.
Lordship. So with this order, Lordship, a precedent will be set, Lordship. So at least there will be some clarity.
Sure. Let me take it.
Since my lord has already understood the case, will I be needing to place my citations or that will not be necessary?
heard Ms. Neetu Kosa, the learned counsel appearing on behalf of the petitioner. And Mr. Dukam, the learned counsel appearing. Nangami, the learned counsel appearing on behalf of the respondents. Why the matter is going like this? So many orders, records call. Okay. The petitioner herein have invoked the jurisdiction of this court under Article 2 to 6 of the Constitution, challenging the communication dated 3rd of June 2024, issued by the Director Higher Education, Nagaland, there is the respondent number 4, the instant proceedings, semicolon, for setting aside the circular dated 4th of June 2023. Earlier one is the issued by the respondent number 4, semicolon, for setting aside the advertisement dated 4th of June 2024. And the notification dated 19th of June 2024. All issued by the respondent number 4. Agote respondent number 4 boli erat question na have issued challenging 3rd of June notification, 4th of year, 4th of April, semicolon DD, all issued by the respondent number 4. First, the challenge made to the above circulars, notifications and orders, communications, advertisements, the challenge made to the aforesaid notifications, communication, circulars, advertisement and notification can be discerned upon perusal of the facts which led to the filing of the instant writ petition. First, the petitioner herein was appointed as a lecturer under the Higher Education Department of the Government of Nagaland by an order dated 2012-2006. First, the petitioner rendered his service efficiently. First, the petitioner thereupon rendered his service first. After rendering his service for more than 17 years, the petitioner was promoted to the post of associate professor from the post of lecturer. First, you have a PhD. On 24th of May 2023, the respondent number 4 issued an advertisement for the post of principal calling for applications from eligible candidates in the government colleges in the academic level 14, bracket 14, 1,44,200, and special allowance of rupees 2,000 per month. The said advertisement stipulated the various eligibility criteria. First, there's no denial to the effect that the petitioner was eligible to be considered for the purpose of promotion to the post of principal. First, the petitioner accordingly participated, submitted his application along with others, and participated in the said selection process. The petitioner was called for interview on 8th by the notification dated 8th of August 2023, along with 9 others, for selection to the post of, for promotion to the post of the principal. The selection was the selection committee published, made the interview. The selection committee, after making an interview, and after the oral interview, published the interview assessment sheet. First, in the said interview assessment sheet, the petitioner was at serial number 5 and was waitlisted at with remark waitlist -2, Roman 2. From the very interview assessment sheet, it appears that 3 persons were selected, were recommended. Subsequent thereto, the 3 persons who were recommended were promoted to the post of principal and posted at the colleges mentioned in the notification dated 20/10/2023. The materials in record further show that a communication was written by the respondent number 4 to the Commissioner and Secretary to the Government of Nagaland, stating it dated 29th of April 2024, stating inter alia that whereby a proposal was mooted for appointment of to the post of principal against 2 anticipated retirement vacancies in May and June 2024 at Junubetu Government College Junubetu and Wangkau Government College Mon. In the said communication, it was written that there was already a select list. There was already a recommendation made by the interview board held on 17th of August 2023, which was valid for 1 year. And under such circumstances, the petitioner, along with another, were proposed by the respondent number 4 to be appointed against the retirement vacancy. The record further reveals that on 22nd of May 2024, the vigilance, the Deputy Secretary to the Government of Nagaland had given a vigilance clearance in respect to the appointment to the post of the appointment of the petitioner to the post of the principal. Subsequent thereto, the respondent number 4 issued another communication on 3rd of June 2024, wherein it was mentioned that the Nagaland Higher Education Service Rules 2015, for short, the rules of 2015, do not mandate is silent on the number of months a select list would be valid. However, as the NPSC recommends waitlist period for only 6 months, the department may go for a fresh selection against the two vacancies which have arisen. Subsequent thereto, the respondent number 4 issued a circular informing all concerned that the principal, the recommendations so made by the interview board on 17/8/2023 to the post of the principal was no longer valid in view of the expiry of 6 months. And the candidates who were waitlisted were advised to submit fresh application to the post of the principal. On the same date, an advertisement was issued for the post of the principal. From a perusal of it is further seen that the respondent number 4 have also issued another communication on 4th of June 2024, wherein it was mentioned that there was 1 vacancy and 2 anticipated vacancy. Subsequent thereto, the petitioner duly participated in the said selection proceedings for promotion to the post of the principal. The petitioner, which is apparent from the notification dated 19th of June 2024, whereby the petitioner was informed that his oral interview would be taken on 24th of June 2024. First, it is further relevant at this stage to take note of that pursuant to appearance in the oral interview, the petitioner was again waitlisted. The interview board in the pursuant to the appearance of the petitioner in the oral interview, the selection board issued an interview assessment sheet for the principals, wherein the petitioner was put at serial number 5, and against him, the remarks put were waiting list Roman 2. It is also relevant to take note of that on the basis of the said interview assessment sheet, which was prepared on 24/6/2024, and the further notification was issued on 15/7/2024, wherein the 3 persons who were at serial number 1, 2, and 3 of the interview assessment sheet were appointed to the 3 posts for which the selection was held. It is relevant to take note of that the instant petition was filed on 26/7/2024. And there is no mention in the writ petition was filed on 26/7/2024. But there is no challenge to the challenge to the interview assessment sheet prepared on 24/6.
Because it was not notified.
You filed subsequently.
No, it was the respondent who has filed, submitted in the other employee.
No, you have categories said in paragraph number 18. Can you see? Paragraph number 17, see? Isn't it?
Yes, Lordship.
I filed the writ petition on 26/7/2024, but did not challenge the interview. The interview assessment sheet, which was prepared on 24/6/2024, as well as the notification issued on 17th. Yeah.
I'm challenging notification dated 19 June, but the assessment.
19 June, madam, no, madam, 19 June is a notification where you were asked to come for oral
Yes,
interview.
Lordship.
You participated then. You should have challenged this one.
Yes, I am challenging this petition. However, Lordship, it is humbly clarified that the interview assessment sheet, Lordship, dated 24th June, was not notified, Lordship.
Understood, but you have it there. You
Yes,
did not challenge 24/6. You are challenging 19/6.
Lordship, yes.
19/6 is by which a notification has been issued asking you to appear in the oral interview.
Lordship, so that is.
Why are you
impugned.
challenging that?
That is impugned, Lordship.
That has no relevance. Anyways, I'll take care of it, don't worry. 24th here, as well as the results dated 17th of August 2024. First, in the backdrop of the above, the case of the petitioner herein is as the petitioner was selected at serial number 5 in the interview assessment sheet dated 17/8/2023, and the respondent number 4 had issued a communication to the Commissioner and Secretary to the Government of Nagaland that the recommendation of the interview board held on 17/8/2023 was valid for 1 year, the petitioner ought to have been considered for the purpose of promotion to the post of the principal against the 2 anticipated vacancy. Isn't it? Mr. Enangami, the learned counsel appearing on behalf of the respondent, submitted that a perusal of the rules of 2015 submitted that the instant writ petition cannot be maintained, primarily on the ground that the petitioner had participated in the subsequent selection proceedings for the purpose of promotion to the post of the principal against the 2 anticipated vacancies, against the 3 vacancies, of which 2 were anticipated vacancies. First, the petitioner thereupon, having not fared well in the interview assessment carried out on 24/6/2024, and subsequently notification was issued whereby the persons at serial number 1, 2, and 3 of the interview assessment sheet were appointed to against the 3 vacant posts, cannot be permitted to file the instant writ petition. He submitted that once the petitioner have already subjected himself to the selection proceedings, the petitioner cannot be permitted to challenge the selection proceedings. In addition to that, the learned counsel appearing on behalf of the respondents further submitted that the right of a waitlisted candidate is only to be appointed against, well, to be appointed would only arise if the selected candidates do not accept the appointment. He submitted that once the appointment is already being made, comma, the list gets exhausted. Nothing. I've heard the learned counsels appearing on behalf of the parties and have given my anxious consideration. First, this court finds it very pertinent before this court, before dealing with the facts involved in the instant proceedings, finds it very pertinent to take note of the rules of 2015. From a perusal of the said rules of 2015, it is seen that a method of recruitment to the post specified in Schedule 1 of the rules of 2015 shall be either by direct recruitment or by promotion. In Schedule 1, it is being mentioned at serial number 1, Roman 3, that the post of the principals of Government College is therefore to be recruited in terms with Rule 4 and Rule 5 of the rules of 2015. Is to be recruited, therefore, in terms with Rule 6 of the rules of 2015. First, Rule 7 of the rules of 2015 refers to direct recruitment. Schedule Roman 2 where the Roman 2? Roman 2 schedule here, schedule 1. Where principal is there, schedule 2? Not there? Yes. In terms of Rule 7, comma, the manner in which the direct recruitment is to be carried out have been stipulated. First, it is very interesting to take note of Rule 7.6, Roman 6, which stipulates that a wait list not exceeding 25% of the vacancy advertised shall be maintained by the Commission in respect of a written examination and interview conducted by it. The waiting list shall remain valid for a period of 6 months from the date of the results declared by the Commission. Per contra, if this court takes note of Rule 12, which stipulates the procedure of recruitment by promotion or placement, there is no mention whatsoever as regards maintaining a wait list. What is mentioned thereupon, what is seen from a perusal of Rule 12, Roman 3, is that the Commission, after the committee is to meet and prepare a select list based upon the criteria of merit cum seniority. In order of preference equal to the number of vacancies or anticipated vacancies to be filled by promotion during the recruitment year. Therefore, from a perusal of Rule 12, which specifically deals with the manner in which the procedure of recruitment by way of promotion or replacement, the concept of maintaining a wait list is foreign. Isn't it? It's not here, because when the legislation gives two things, contains two aspects. For 7.6, it is a wait list, but not for this. So the question of there being a wait list does not arise. So there will be a marking only. It's foreign. First. In the backdrop of the above, if this court takes note of, in the backdrop of the above, taking into account that the criteria for promotion is merit cum seniority, it is relevant to observe that the settled proposition of law stipulates that the principle of merit cum seniority postulates the following. A, merit plays a predominant role in, and the seniority alone cannot be given primacy. B, comparative assessment of merit is a crucial, though not mandatory factor. C, only where merit is equal in all respects can inter se seniority be considered. Meaning thereby that a junior candidate can be promoted over the senior if the junior is more meritorious. In the backdrop of the above, if this court duly takes note of the case of the petitioner, it would be seen that the petitioner herein, as per the interview assessment sheet dated 17/8/2023, had only got secured 50.71 marks. First, though the petitioner was put at serial number 5, applying Rule 12, Roman 3, the petitioner could not have been put at serial number 5 as the mark secured by the petitioner was the least amongst the 10 candidates. Full stop. Therefore, the question of, well, full stop. In addition to that, this court finds it very pertinent to mention, pertinent to observe, that when in a rule, the rule-making authority have in different places, in one mode of recruitment have categorically mentioned that there would be a requirement of having a wait list, and in the other mode of recruitment have stated, did not mention the requirement of having a wait list. The concept of having a wait list in respect to recruitment by way of promotion does not arise. First, under such circumstances, in that view of the matter, the writ petition filed by the petitioner lacks merit on this count alone and is required to be dismissed and ought not. It lacks merit. Footstop. This court further finds it relevant to take note of that the petitioner thereupon participated in the selection process, which was initiated on the basis of a advertisement dated 4th of June 2024. Footstop. The petitioner did not again fare well in the said examination. Footstop. And after having not fared well, the petitioner have approached this court challenging the select list, challenging the inaction, the advertisement, the circulars, the notifications, etc., impugned in the instant proceedings, as already noted supra. Fusto. In the opinion of this court, the petitioner having subjected himself to the second selection proceedings by appearing in the interview and further having not been qualified, could not have maintained the instant petition. Consequently, this court finds no merit in the instant petition, for which the writ petition stands dismissed. Principal seat is a case of cost, but no cost here. Yes, there was nobody supposed to argue, and then I see if some lawyers here again. Yes, Ms. Jimomi.
This item number 19. The council's I have with my notice.
Your meeting is over?
Meeting is over.
Meeting is over. So how many matters are left in the admission and orders items? Huh? 12. Give it to us. Let us pass. I'll pass orders, wait. I'll go by serially, which is left.
For admission, item number 5.
So, let's find this on what senior counsel for responding about. About where here where is the parliament?
Wait. Huh?
So where here the parliament?
File affidavit for respondent.
Respondent number 1.
Why you have not filed?
About where is the instruction?
Huh?
Where is the receive an instruction?
You are yet to receive any instruction. What interim order has been passed? My goodness, there's an interim order passed as regards income tax department. And the income tax department has not filed affidavit.
This one. Where do you receive an instruction?
Huh?
Where do you receive an instruction? Which getting has been forwarded.
You are the income tax department.
Yes, ma'am. For responding number 1, you taking.
What are you challenging?
I'm doing on behalf of my seniors and young officials.
Huh?
appearing on behalf of my client.
No, you don't know anything. You don't know anything.
This matter pertains to income tax.
Then
Most of the interim order is to stay the assessment order.
that I also know. Further beyond that. Huh? What? And you are paying for whom? Gauhati can't do anything with the income tax council. Why you are making the joint commissioner of income tax? And why you are not going filing an appeal? Yes, Mr. Council. Why haven't you filed an appeal? Alternative remedy is there. Why have you approached 226? Tell me, give me a good reason for that.
See, my apology, I'm not fully conversing with the facts.
So, if you are not conversant, I also don't know. You cannot also pray for an extension of the interim order. Isn't it? Can you pray for an extension of the interim order? If you can't, why should I extend? Chalo. So you are only appealing for response number 1. What about service upon response number 2? Oh, somebody is there. They have filed the affidavit. He has not appeared. Mr. Sumon Setia. He has not appeared. Okay. It is seen that response number 1 and 2 are represented. But none of the say their respondents have filed their affidavit. It is seen, more particular, it is very pertinent to observe that there is an interim order operating whereby operating since 25/2024. And the respondent authorities, more particularly the respondent number 2, seems to be not bothered to file their reply or even put in their appearance. Considering the above, this court adjourns this matter to be listed again on 15/5/2025. A copy of the order be sent to the registry shall send a copy of this order to the Joint Commissioner of Income Tax, who is the respondent number 2, so that appropriate steps can be taken by the said authority for appointment of for engagement of a counsel to protect the interests of the Income Tax Department. First, the interim order passed earlier shall continue till the next date.
For admission, item number 6.
Lordship, on behalf of Tiba, the state is received instructions, so it should start in front of the committee with Lordship.
For what? Filing affidavit
Lordship,
by the government.
Lordship.
This is 26, 2024 notice was issued. After 1 year, is it the tradition? In Nagaland, that after 1 year, one should file an affidavit, not before that. It is something like that. Every time is being sought for, you impose a cost, 10,000.
Lordship,
10,000?
Sometimes we call it lordship, this,
10,000 cost.
state serious instruction lordship.
We impose a cost of 10,000 for acceptance of the written statement. What is the case, madam?
Your lordship, it is a matter of service regularization.
Regularization.
Yes, your lordship.
The instant repetition was this court, by an order dated 26/2024, have issued notice. First, copies of the writ petition were duly provided to the council representing the official respondents. First, since then, the matter had been listed before this court on various occasions in the interval of 2 weeks or 3 weeks. But the state respondents have not filed their affidavit. First, today also, time is being sought for on the ground of filing an affidavit. First, there's no good reasons assigned as to why no affidavit could be filed on the earlier occasion. First, considering the above, list this matter again on 6th of May 2025. First, a final liberty is being given to the respondents to bring on record their stand by filing the affidavit. First, taking into account the negligence and the laches on the part of the respondents in filing the affidavit, in not filing the affidavit and seeking and delaying the disposal of the proceedings. This court imposes the cost of rupees 10,000 upon the respondents. First, the deposit of the 10,000 shall be a condition precedent for receipt of the affidavit. For accepting the affidavit of the respondents.
For admission, item number 7.
Let's mention on behalf of the Miscellaneous, your lordship, to extend the continued final affidavit.
Affidavit filed, same order,
Yes, sir.
same order.
Our worship, as this is the sixth occasion that we are going to file a affidavit.
Fantastic.
If the last chance.
10,000?
No,
No, this can't happen because the other lady will say that I have been biased. Same order. Notice it to side play to you, 10,000. Same date filing, cost 10,000.
For admission, item number 8.
Yes, what is this?
Worship, I'm appearing on behalf of my seniors and young worship. Worship, my senior has left for his some urgent work, worship. So here we are here to file academic in reply to the academic position. Therefore, kindly grants 3 weeks time.
Wait. Direction to quash and set aside the impugned letter issued by the AR to the petitioner conveying that the contract agreement stands rescinded the AR. How can there be a stay to a termination? Is it heard of, Mr. Angami? Have you ever heard of a stay to a termination? Have you heard? I've never heard. Can the court of law say that a person has died? Okay, no problem. I put a stay to that. Something is dead. How do you stay it? Your senior had to leave. This is the matter tomorrow. Not entering this type of order. This order has to be vacated. Mr. Soundson, the learned counsel appearing on behalf of the petitioner, submits that his senior had to leave the court for urgent purpose. Pusto. This court have duly taken note of that there is that no affidavit that there is an interim order operating in the instant proceedings, whereby the termination of the contract have been stayed. Mr. So-and-so appearing on behalf of the respondent submits that the concept of staying a termination is completely foreign. Under such circumstances, Mr. So-and-so appearing for the petitioner submits that the matter be listed tomorrow. List the matter tomorrow at 2 p.m.
For admission, item number 9.
Yes.
Mr. Lordship, Lordship, the state is on the color of this.
No, somebody has filed an affidavit, 123. You have filed an affidavit. What is your case?
Lordship, regarding the scale of pay.
That day, last time me and Justice Chaudhary was here, we passed an order, division bench.
Lordship, we should be having the law.
Please. This is the asking for the scale of pay, na? Conversion of wages of work charge employees in near to scale of pay as per revision of Iman. Recommendation of Iman and in pursuance to all work charge and cases in all departments names have been duly verified by the Iman. Receive fixed pay shall be granted scale of pay as per the division of Iman with effect from Iman. Therefore, all departments have in work charge directed. So in view of that, the petition should be allowed. Wait, without the petitioner, this lady would not be getting his material instructions. Isn't it? That nothing was done. You didn't do anything. Why should I help you? So we'll have it tomorrow and finish it off. Huh? Tell your counterpart. Ms. So-and-so appearing on behalf of the state respondent submits that an office memorandum was issued on 5th of March 2025, and on the basis thereof, the prayer made in the writ petition and on the basis thereof, this court can pass appropriate directions for disposal of the writ petition. The office memorandum so provided, along with the notification, both dated 5th of March 2025, are kept on record and marked with the letter X and Y. List the matter tomorrow for tomorrow, taking into account that the counsel for the petitioner is not present.
For admission, item number 10.
No, this is Lordship. Lordship, on behalf of control, the biggest anti-termination, so it sometimes it's not the Lordship.
Okay, first time. Matter came up when? Many times. Okay. But you file an affidavit, this is an amount he has not got during the period of suspension, isn't it? Okay. Ms. So-and-so appearing on behalf of the respondent submits that the final opportunity be granted for filing the affidavit to the state respondents, taking into account the matter whereby the petitioner is claiming full pay oblique areas for the period of suspension with effect from 31/7/2018 to 13/3/2020. And the urgency expressed by the learned counsel for the petitioner. The matter stench is fixed again on 29th of April 2025. Full. A final opportunity is being granted to the state respondents to file the affidavit on or before 25th of April 2025. Full. It is observed that if no affidavit is being filed, the instant proceedings shall be decided on the basis of the materials already available in the court.
Lordship, item 11 is also similar. Lordship, similar prayer.
Similar prayers. Same date. But the date will be different, suspension same date.
Suspension is same date and reinstatement is different.
Reinstatement is different. Silable, huh? Period to question kuntu period or kuntu period one. So one I have already mentioned, the other you just check it out. What is the reinstatement date? You will find it in the matter of. Don't see it anywhere. In the matter of. Yes, third page, yes.
12/3/2020.
2020.
Yes.
For admission, item number 12.
Appearing on behalf of my seniority, I was informed that the state respondent has complied with the direction.
Huh?
The state respondent has complied with the.
Complied?
In the expression, yes.
It has been submitted by the learned counsel appearing on behalf of the petitioner that the petitioner have already received the due. You wanted some money? Huh? Have had the petitioners grievances have already been redressed by the respondent authorities, and as such, the petitioner would not like to further press the instant proceedings. Taking into account the above, the instant petition stands closed on withdrawal.
For admission from the supplementary cost list, for admission, item numbers 24 to 35.
Opposite councils are not present.
What are these?
Lordship was order, the letter came up and the opposite party, we are saying that the writ petitions have become infructuous. However, because they have been, while the case was pending, they have been absorbed, regularized.
You have been regularized?
Yes.
So
I
the question is, if those persons have already been regularized, they may not be person aggrieved. There might be other persons. Would you now like to again join that post? Because this is not a public interest litigation.
Yes, Lordship, we have filed RTI for this absorption orders. So likely we have to challenge the subsequent action, otherwise.
No. I'm concerned with the petitioners. The petitioner have all been absorbed.
Lordship. When initial appointment orders are under challenge, they were appointed through Backdoor, Lordship, so.
Now, understood, those have been appointed backdoor.
Lordship.
In a fit case, we will look into it. Somebody challenges it. But in the case out here of these petitioners, they have already been absorbed by the government.
Lordship.
So then why should these petitioners unnecessarily fight? Isn't it an unnecessary litigation for them?
Not petitioners, respondents. Petitioners are net qualified, unemployed petitioners.
Okay.
So they challenge the backdoor appointment of those respondents who were appointed through backdoor for advertisement of the post. Now, while the case is pending, they have already absorbed the respondents. That is our case. So last time when the letter came up, they said that because of their absorption, my present writ petitions have become infractious. Whereas I'm saying that.
Why will it be infractious?
That's why, Lordship.
Cannot be, if the initial appointment is wrong,
That's why. That's exactly what I'm saying, and today it was fixed for argument on the point of law regarding this, but the opposite parties have left.
The other point of that,
Because when we.
no, if the initial is gone, the root goes, the tree cannot.
Exactly, Lordship. If the foundation is removed, the superstructure falls. Subplateau fundamental
So,
carried on
what to do?
opposite. So it may come up.
Yes, madam, what to do?
Let the matter come up tomorrow, Lordship. It's just only on that point,
No, what is that? If I do that, then what happens?
Lordship.
If I hold it, that the petition is still maintainable, then what happens? Tell me the next question. Because I would not be most probably sitting in the single bench next week.
In the last order, if my lord will peruse the last order, they have been, if this has not become infractions, I think they were given 1 month's time to file their affidavit also.
They have to file the affidavit. What is it? They cannot do without an affidavit. Have you filed it?
No, Your Lordship, just now I got an information that like additional meeting, Lordship is taking up the Lordship, so.
No, the affidavit has to be filed. You are not concerned with other things. How can you raise a point of maintainability without an affidavit? Is it heard of? Is it heard of?
Oh, yes, Lordship.
Not heard
In
of.
the writ petition, they have filed. In the writ petition, they have filed.
They have
But-
filed affidavits.
Yes, Lordship. Affidavit, they have already filed.
Then what is required then?
Nothing is required. Oh, it's on the question that the petitions are not infractions. That is what I'm.
Senior counsel that during the day, almost all the private estate has been absorbed in the post of assistant professor, and since the challenge was to the appointment in contractual post. The repetitions have become, oh. I see. So don't you think that you need to amend?
Subsequent,
So why you need it? Because their appointment were contractual.
Yes, exactly, Lordship.
Once it is contractual, don't you think that you need to amend it? If you don't amend it, you may have a problem out there. You challenge the contractual, and from contractual it is being absorbed. Now, absorption also, if it is done, they are not mandated by law. So either
Yes.
you have to file a separate petition and
That's what,
tag along with this.
That is what you take state, Lordship.
What are you going to do?
Uh,
You file a separate petition, but
Yes, I'll do that.
amendment will take some time.
Separate writ petition, we will file and it will be clubbed up together with this.
Better off. So I do one thing, I fix this matter after 6 weeks. In the meantime, you get the time,
Lordship.
better off.
Lordship.
And the other side, because if the other side was here, they would have argued. I would have dismissed your petition.
Yes, Lordship, but that is not possible legally. I have all the Supreme Court citations, that cannot be.
No, I understood. If they were appointed on a contractual basis, you have
Yes.
challenged.
Extension every year. And we have challenged their last extension order also.
Now they have been absorbed.
Absolutely.
So I think
But
you need
it's-
to file a separate. written
Yes,
petition.
Lordship. They have filed, the petitioners have filed RTI and
So what
uh,
should I record? Are you filing amendment or petition?
Writ petition will be
Better.
better, yes, because you can come up in a group.
Mr. Z. Zimo, the Land Council appearing on behalf of the petitioner in the present batch of petitions submits that the petitioners herein are taking appropriate steps for challenging the absorption, the subsequent absorption made to the respondents, private respondents. Which is also not permissible in law. And private subsequent absorption made to the respondents, private respondents. List this matter again on 26th of May 2025. In the meantime, the
For admission, item number 36.
what is this IA business?
So, Lordship, this IA is for seeking alteration, modification of the interim order, which is passed by December of the court, Lordship.
Yes, what is that?
Lordship, in the region, though the release order of the petitioner was, though it was directed not to release the petitioner, there was no stay of the state release order. So we have filed this IA for modification.
You are for?
I'm for the petitioner, Lordship.
Why are you asking for modification?
Lordship, in the first interim, which was granted on 18/11/2024, Lordship. Here there is honorable court granted.
It's hereby directed the petitioner shall not be released from the swimming pool till returnable.
Yes, Lordship.
Then?
So, Lordship, though it was stated, there was no specifically, no mention was made for the stay of the release order. So actually, in fact, Lordship, we wrote a covering letter to the department. However, they have stated that there is no specific stay of the order. So we approached this honorable court verbally. However, we were directed to file the IA. So we have.
Now, what do you want?
Lordship.
What order do you want?
Lordship, our modification is just to the extent of staying the release order, Lordship.
Huh?
Staying the release order of the petition, Lordship.
Release order, should I extend it?
Lordship, in fact, the petitioner was
No, you are asking for modifying, altering the interim order to what?
Lordship, to have a word or specifically mentioning that the release order is stayed, Lordship, till the.
So that order has
Yes.
not been clearly mentioned.
Yes, Lordship, that is the only thing.
Please, my lord. I want to take the worship to running page 23 of Annexure 2 of the repetition. The condition, terms and conditions by which the present petitioner was agreed.
Page?
Page 23, Annexure 2.
Yes.
Yeah, read my lord.
On recommendation of the selection committee vote for so and so on its meeting held on Nimado. Who is the petitioner? Is the petitioner?
He is the petitioner.
Major Kohito Asumi.
Yes.
Okay,
The
then
terms and condition is that he was initially appointed for a period of 2 years. So successively, he had been appointed, extended every after 2 years, and then his service was utilized for the last 10 years. And by order dated 1st November 2024, he was released from service after completing 10 years. He retired from 31st.
where is the order?
My lord, it is at running page 44.
So every 2 years you extend it.
Yes, ma'am. And the condition-
So now you have not extended it.
No, and then he was appointed on fixed pay basis.
Huh?
Fixed pay. As a ex-serviceman.
As per section 3D of the Government of India guidelines, dated Majoya, so and so is hereby released from service with effect from here on completion of 5 years. So he has done 5 years only.
Per year, including starting from 2014 If you have to count from the entry point,
Ah.
he has completed 10 years of service. After 2 years, his services was utilized for the same case. And his service was released with effect from 31st August 2024 by order dated.
So every
1st
time it
November
is being
2024.
extended. Now he has been released.
Yes, ma'am. So since he has been released from service, the interim period, which is continuing, may be subject to the outcome of this regulation. Because we are preparing the affidavit. We will be filing our affidavit within a period of 2 weeks. Since he is no more in service.
My goodness.
And for lordship here, the petitioner was
The
released.
council, this is not an order which can be extended. Person's conscience also should permit.
Lordship,
You have
however,
been, just for example, tomorrow you lose up, you don't take the pay, okay? Are you agreeable? You don't take the pay and you work. You win the case. Then,
Yes,
are you agreeable?
yes.
Because tomorrow you lose the case. The question would be, are you going to return the amount? A person cannot, therefore there cannot be a stay of a release. You could have an order passed prior to release, but after the release, how can there be a stay?
in fact, lordship here, in my case, lordship, where the petitioner was released basing on the new guidelines, lordship. So this it was retrospectively released, or the petitioner was retrospectively released basing on the new guidelines. So however,
But your very notification by which you have been extended till 31/8/2024 categorically mentions that your service is only 10 next date. What is your right to continue thereafter?
lordship, because the when it comes to the petitioner's case, lordship, the old guidelines is applicable to in his case, not the new guidelines, lordship. And in fact, there are many other who are similarly situated persons. They are still in service. Only the petitioner was released from the service.
Certainly the similarly situated person.
Lordship, that
who are
I
in
agree.
the service.
How he was illegally released, lordship, basing on the new guideline. The new guideline is not applicable in my case, lordship. That is our case, lordship. It was the old guideline is applicable to the petitioner, not the new guidelines.
What was the old guidelines?
Lordship, there's a certain conditions that has to be followed. It is till the 60 years or till the age of 60 years or 65 years, lordship.
As per that.
60.
But then why are you
Okay.
why did you accept those type of appointment orders then? Why didn't you challenge those appointment?
No,
Which says that it is only till 31/8.
here as per the guidelines, like the petitioner is not the old guidelines, the petitioner is not accurate, lordship. And in fact, the petitioner is only, if we go by the age, lordship, he is only 45.
Oh, you have good. Go ahead, do some other work.
But let the state file their opposition.
Let them
lordship.
file their affidavit.
Lordship.
And notice. And this has not been extended, na? Interim order till the next date of listing, okay. And then on 13/2 there is no extension. So there is no interim order now. Okay.
On 2025, the IO was heard, lordship.
This
And
one?
the interim.
This
I
one?
is lordship. I 13 of 2025. Here we were given the interim.
It was a given?
Yes, lordship. 2025.
What is given?
I had 13 of 2025 on 2025. lordship. Here we were given an interim. Was suspended till the next return of the day.
I'm not extending these type of orders. It is not possible. Let us go by the fact that it has not reached.
So let that go.
Why did he appear? I would have said none appears for the petitioner.
Sure.
Okay, Mr. So-and-so appearing on behalf of the respondent submits that some time may be granted for filing the affidavit. So taking into account the matter in its entirety, list the matter again on 7th of May 2025. The affidavit be filed by the respondents on or before 30th of May 2025, April. 50th of April 2025, the petitioner is advised will be at liberty to file the reply.
I was supporting to make a motion for a short deadline, Chair.
7th May. They have to file the affidavit, na? But you don't file, we impose cost. This court further observes that taking into account that the issue involved in the instant proceeding is as regards the legality or validity of the release order, comma, and release order, comma. It is observed that if the respondents do not file the affidavit on the date so fixed, this court shall proceed with the disposal of the material of the affidavit of the petition on the basis of the materials already available.
For hearing, item numbers 13 and 14.
But this order for finding inquiry has been submitted, but it appears that is clearly making up of the inquiry.
Yeah, Mr. Longkuma, why this matter is pending from 2016?
No, yes.
Why? Something is wrong. Did this matter never come up before me? No.
My lord, before we proceed.
I think this one, my order. I gave a long order. Yes. Named the Longshore so and so has filed seeking an investigation into the death of lethargy who died in the lockup at the police either by the Central Bureau of Investigation or to appoint a commission of the petition seeking damages on the account of death in the lockup. It reveals that 1:25 p.m. the so and so arrested by the police. So and so at the time of the arrest, the has been by the arresting. The court symbol was seen by the detaining of the symbol is far from being first. What is this the one where he was hanged?
Yes.
I remember, yes, when a new party checked the cell when he was confined, they found that the cell was empty. The record revealed the same of Peru, the magistrate inquiry report, which under no circumstance can be said there is a report by Minister of the Up to the ventilator of the toilet in the addition to the fire which has been so under such the court direct the learned district judge to carry out the fire. Oh, what happened? Inquiry report?
Inquiry report is before your notice.
Oh, what happened?
The only thing is that.
Mr. Longshore.
Yes.
This matter is, I think, needs to be done because nothing has happened. I mean, sir, I'm sorry to say that after I left this matter in this manner, nothing is done. Everything the matter is getting.
So, what I am saying to your lord is that we were not allowed to participate in the inquiry. Even the person, the complainant is the brother with the reporter to the magistrate for inquiry, the counsel people not allowed to.
The documents which have been placed before the court by the Chief Judicial in a seal cover be sent to the district judge as the same May 8th in the year. Registry the court directs the super as well as the officer in charge to provide necessary to the learned Kohima for conduct. District for conduct shall have the power to the commission. This is the matter. Because they for taking because informing the superintendent. This court direct the learned to carry out the inquiry regarding the date and submit a report before the court within 3 months from the date of receipt of the instant order, along with the papers enclosed therewith. The inquiry has come.
Inquiry has come.
Inquiry had nothing to do as regards you participating or not. The question is, where is the inquiry? Let's see.
Inquiry.
Where's the report? Is it? 11. Is it the record of the Gauhati High Court? Yes, issue summons. Yeah, let us see what is the report. Yes. My name is Eric. This is all real. Where's the report? We do one thing, Mr. Longshan. Although I may not be sitting in the division next week, but this matter needs a culmination. Because whatever may be, something or the other has to be done out there. And I have already dealt with this matter in detail earlier. Where is the report? Have you seen anybody the report? Where's the report of the inquiry?
Report was submitted before the vote from there.
Some photographs being given. Where's the report? Inquiry arising out of so and so, record of so and so.
It was citing them.
Huh?
Copy.
Single copy.
Yes.
Okay, here it is. Okay. So let us see what it is done. And then no evidence to show that he was offered the sum of the asking him to close the case by the in charge. Information was not about the state installed in there. You have a copy of it?
Manas.
You have a? What is wrong?
But everything it said is that the disease was arrested by the public from people only. That is their version. There is an entire case. It is not the part of the report. It appears that he was given to the.
No, the question was
Mano.
as to whether the death which had happened in the lockup was on account of any fault of the police. That's it. Let's not go into the question of arrest. Arrest he was done. There's no quarrel with that.
Oh, this is to make an inquiry how the person died. It's not, I'm not questioning about the particular personality. I, the still want to know how.
Examination of the witness on the witness.
What?
How was it possible for Lydia to tie the cloth on the ventilator of the toilet? I cannot say how he met. Huh?
Page 40.
Page?
Page, the gist, page 3, page 4, paragraph 2. And out of the 8, 4 would not make an appearance because they have expired.
Yes.
And the
Which one? Okay.
The IO is examined, the doctors have examined, the complainant also examined, all the things are wrong.
Because one thing, Mr. Longshar, one has to understand. You have come before this court under 226, asking for an inquiry by the CBI or whatever may be.
That is what exactly is mine.
Now, for doing so, the question is first as to whether the investigation is done or not is the question before this, for which I have asked for a fact-finding inquiry. Now, on the basis of the investigation which was being carried out, if it has been said by a fact-finding inquiry being carried out under power being exercised under the Commission of Inquiries Act, the scope of this court is very limited. Because you see, the first is as regards investigation, further investigation is to be carried out by the CBI. Now, on the basis of that, the Commission of Inquiry, the inquiry has already done by this authority. So that part has already been taken care of, which the CBI would have otherwise done. Because here the Commission of Inquiry is being given. Now, the report of a can be assailed how? How can it be assailed? Tell me.
My submission is that there are indicators in the inquiry which needs to be investigated into. Number one, that this is happened to be addressed by the police personnel on the basis of a address by a public. Then there was a FIR. There is no FIR before this court. In the inquiry, it was
let me do one thing. No, let me do one thing. Let me go through this inquiry report. And then I'll hear you on Monday. Monday or Tuesday, I'll hear.
What I'm saying is that I'm not finding fault with anybody. What I want to know is that how the person died. Inquiry report speaks about him. What was the material? Somewhere it is said to be below cover, somewhere bed sheet. Somebody saying that only a tongue was in the lava. It was alleged by the public.
No, Mr. Longsha, you look into another aspect. What is the scope of the power of this court to override the inquiry report?
I'm not saying that it should be override.
No, I'm asking you. Then what is the next? Because the inquiry report holds that there was no fault.
On the part of the police person.
So the question is, if the police is not at fault, there cannot be a question of giving any liability, imposing any liability or tortious negligence, tortious compensation. You are asking for a constitutional tort. So for passing an order of constitutional tort would not be possible.
That is the next petition.
Yes, the petition. Now the next petition, the constitutional tort is not possible. Unless I have to say that there is something which is wrong with the inquiry report. So therefore, with this inquiry report remaining out here, now your basic idea is you want to know what is the truth of how the person died. That's your case?
No.
The petitioner also made out the case that the accused was brutally tortured by the police. The main petition was all about that. So your lordship, now the reports, as rightly observed, your lordship can go through the report and it can't be.
Let me go through the report and then we'll hear you on Monday.
No.
2 p.m. Monday after I rise from the DB. Okay. If I sit in the single, it's okay. But if I'm sitting in DB, because there will be on Monday 3 judges. So if I am sitting with Justice Jameen or Justice Pathak, then I'm sitting in DB. But then I'll sit in the single and take it up after the rising of the DB. Or if it is not possible, then something is written. I'll make it parted.
No problem.
Because taking into account the matter has been going on for long, and I am only the person who has passed this long order. The facts and all I have there. Let me have a look at it Sunday. Let me go through it. Hey, give me this report. Give me you have all got a copy.
Yes.
I'll make a photocopy of this report and give it to you. Huh? Is there an original copy? Give me a photocopy and give it to me in my office. The matter have been heard at length. Full stop. Further hearing would be required after due perusal of the inquiry report, which would be there and then full stop. This court therefore would hear the petitioner as well as the respondents again on Monday, put the date, huh? Monday after Monday, full stop. The registry shall list the matter accordingly before this court. Huh? Showing it as part of it. Give me a copy of it, huh?
For hearing item number 19.
How many matters are there? No more. What is this?
Lordship, this is a landowner appointment case. In all fairness, Lordship, if we go by I pleaded that I am the landowner. There are 3 landowners and I am one of the landowner of EEPWD R&B Auto division. That is what I pleaded. That as a counsel, I wrote here. Now, in all the documents, IA Midland and this petitioners, three landowners donated land to establish the office of the EEPWD R&B Auto division in 1984. Now, what has happened is, Lordship, we are from Midland who donated for the office of sub-divisional officer, sub-division office authorizer. Then IA Midland, they donated the establishment of EEPWD.
Wait. What about the inquiry report? You brought it on record? This is an inquiry report made in terms of 3B?
Yes, I am.
Hmm? Yes, by filing an affidavit. Where is that?
Page 6, not page number 6 of the government affidavit in opposition.
Affidavit 5, respond number 5?
Yes, no, this is the government. They are saying that, Lordship, if my lord will kindly come to page 6 of their government affidavit.
No, this is a notification. I'm not on that. This is a notification. What about the inquiry report?
The subsequent inquiry report, Lordship.
Yes. Where is it?
Page 10, Lordship.
Page?
Page there and excerpt
Of?
my additional affidavit, Lordship.
Additional affidavit.
Lordship.
Where is the person from respond number 5? You are there. Okay.
Respond
Okay.
5 was appointed through the John.
Who is the petitioner? Name of the petitioner?
I personally, Lordship.
So the land where the subdivisional PWD RNB is situated belongs to somebody else, not you.
No. The subdivisional office land belongs to us, to me.
But you have
Choti.
stated before the authorities.
No, Lordship, what has happened here is the authority asked me to, basing upon this report only, Lordship, the petition can be disposed of. What I'm saying is that, Lordship, here what has happened is, I was asked to submit an application when inquiry report was done, and here in all my pleadings, I have stated that we are the owners of subdivision office, not the executive engineer's office. They are 2 kilometers apart. So here what the respondent has done is 5 admission by Sri Virgotoi Sema regarding his petition. Here I was asked to admit and to say that I falsely claim that I am the landowner of the executive engineer office PWD. However, in my writ petition, I pleaded that depending upon since this subdivision office also comes under the executive engineer. Executive engineer is the
But
subdivision head.
madam, with a fact finding like this,
Lordship.
way out is how do I do it under 226? I have to either, because here on one hand, on the pleadings, you are saying that you have nothing to do. You have donated. On the other hand, on this report, it is said that you have not donated. That is your statement being made before the authorities. So under such circumstances, this document is also not on challenge.
Well, that's big, Lordship. I wanted to file affidavit in opposition, but in all fairness, Lordship, they have stated that Nitovi Chopi, son of Let Hekhevi Chopi, Bokatolisi Nidautor-in-law has been appointed in place of Nitovi Chopi lineage. That is what they have stated. So, in all fairness, my only humble prayer before this honorable court is that let the respondent number 5 was appointed. He's not even a citizen of Atoizil. So he was appointed. So the appointment that was met can be quashed, and general advertisement can be made for the citizens of.
But the fact remains, who is the respondent number 5? Obviously, it is not you, but what is the name of the respondent number 5?
Otoka Aye.
Huh? Here, Otoka is not here.
Lordship, here in the government affidavit at page 10, Lordship, they have the clarification on the appointment of Shri Otoka, that is the respondent number 5.
Otoka, it was further clarified that the appointment is not related to the issues petitioner Iman as originally claimed. The appointment of Otoka is not related to the issue. What do you mean by this, madam?
I have challenged his appointment order because he's not a landowner. He is appointed.
Is he a landowner? But petitioner cannot be a landowner. So on what ground have you challenged?
Lordship, in my application, I have challenged the appointment of the respondent number 5, because he is not a landowner. Where I'm saying that I am the landowner of subdivision office. Even the recommendation by the.
So you want to say that as the respondent number 5 was not a landowner.
Landowner, yes, and appointed without recruitment.
And as such, the respondent number 5 could not have been appointed.
Yes.
The appointment of the respondent number 5 should be struck off.
Yes.
And it should go for general appointment.
Advertisement.
General.
That is just not to waste the time of this honorable court, and in all fairness, let the post be advertised, or the petitioner as well as whoever wants to apply can apply in the general advertisement. And my simple humble right before this honorable court is.
Now, madam, you have been appointed under what provision? Landowner?
No, being an indigenous.
Being?
Obligations. He's an indigenous person. For the,
Madam, please use the mic.
Lordship, I have filed my affidavit stating that being an indigenous of the citizen of the village, Lordship, the town, I have been appointed on that basis. And in fact, Lordship, the petition, the respondent number 5, he was appointed after following the due procedures of law, not on the basis of backdoor, Lordship. He submitted his application and also, which was also approved by the state, and after that only he was appointed, Lordship. And in fact, Lordship, there is also a
There is no advertisement, Lordship.
Lordship, there is an offer. I have filed my affidavit on 6/14/2025.
Your affidavit is the biggest affidavit, no?
Lordship, I have a next. In fact, Lordship, our one law is also that it's they have already availed the appointment, Lordship. So as per the
What appointment?
they have already availed, the family of the petitioner have already availed the appointment, Lordship. So we are
On landowner basis?
Yes,
No, we are
Lordship.
not concerned with that. She also gives her claim as landowner basis. Now, let's see your appointment. How is it? What is your name?
Otoka.
Otoka. Where is it?
Lordship, the
I am
appointment.
directed to refer to the cited and convey the approval of the government for appointment in respect of the following person in a vacancy and
Yes,
the
it's
name subject to condition the post are vacant. Where is your name?
Seven
FCP?
of 24, Lordship. The type copies of page.
Yes, Otoka A. So and so division promoted to Daftari. So you have been appointed.
Lordship. In place of. Okay, beyond.
Approval. This is for approval. Where is the appointment order?
And it's at page 22, Lordship. And it should be.
Consequent to the approval of the government for my education and graduate son of so and so, so and so. Promoted to him one in the big shall be on promotion of 2 years of completion. Charge. Okay, now you have been appointed how?
Lordship, as per the OM, Lordship.
Where is the OM?
Lordship, I have, since earlier there were no question of backdoor, Lordship, so we have not annexed all these necessary, but some of them.
So now you are not backdoor.
Lordship, no, yes, Lordship.
You
And in
have
fact,
the government and
OM,
you have appointed in multitasking force. And the engineers who are in the previous scale of the appointed along with the duration of 2 years.
Lordship, as per this OM, Lordship, the government, even if it's not advertised, Lordship, when it comes to the grateful, Lordship.
No, Lordship. This is for conventional appointment and landowners.
So, Lordship, in fact, Lordship, here, this is not the only case where the grateful has been. In fact, there are so many other applicants also in this case, Lordship. When there is a vacancy, the applicants can apply for the said vacancies, Lordship. So the question of advertising the post is not a resolution. Lordship, though this court has the power to, however, Lordship, in my respectful submission, Lordship, we were appointed after following the due procedures of law. That's my humble submission.
So in terms with that, there was a selection.
Lordship, no. There were, I'm informed that there were some other applicants also. However, after going to discipline, in fact, Lordship, my lord, we see this application of the respondent number 5, Lordship. When we expected.
Madam, why don't you bring on record that aspect by way of filing an affidavit?
My sincere apologies, Lordship. In fact, we told of how since we were at the time of hiring, so we came to know only regarding the advertisement. So this is the application when you first applied for the said post, Lordship. So there was this.
Therefore, only Madam Jimumi can object further.
But Lordship, initially, there was no pleadings of the advertisement, Lordship.
Have they made any pleadings now?
Lordship, they have they were purely basing on the land ownership, Lordship. So when it comes to ownership, land ownership, Lordship, it's very clear that the OM clause 3C is very clear, there is no perpetuity in the appointment, so Lordship, we were basing on that, Lordship. So we did not elect this documents.
In landowner appointments, Lordship, this is the person who in the verification.
Don't give me all this.
Yes.
First of all, the council is appearing on behalf of both the petitioner as well as the respondent number 5 have placed before this court various documents. First of all, this court is of the opinion that taking into account the submissions so made, these documents be brought on record by filing additional affidavit by both the petitioner as well as the respondent number 5. First, list this matter when
After 2 weeks.
list the matter again on 28th of April 2025, 29th of April 2025. In the meantime, the additional affidavits be filed by 25th of April 2025.
My sincere Lordship, if we can be on the 1st of May, then I have some difficulties on 29th of May.
Okay, 1st of May. Okay, 1st of May. So at last I could finish my list. Itu kes tu. Dispose of that one which I disposed of 38, huh? Okay.
Oh.